That's why, my lord, I got it assigned.
Let us hear it on 7th.
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 ठीक है.
8th
Yes,
is your date. Before that,
7th.
we'll complete it.
Yes, yes, your lordship. I am ready.
Yeah, very good. Very good.
এবার
Recording.
আমার কথাটা গেল এতক্ষণ পরে।
Heard learned advocates appearing for the respective parties. List
Hearing this will take time.
I'm grateful.
will
Yes.
it will take a long time. No, shouldn't.
Should be.
Half an hour, 45
yes.
minutes, hardly.
If it takes longer than desirable, then in that case, you
No, let
don't
us
the
start on that
execution,
day.
not on
Let us, we will see.
Since I'll be in season, don't do it on 8th, do it on 9th, 10th.
Yes,
If I am
yes,
unable
yes,
to
yes.
do it on 7th.
But in that case, my lord would kind of
Extend, I'll extend.
definitely.
I'm grateful.
And that is understood that on that day, if
I'm
I-
giving my words.
because it won't be, it will be improper.
No, no, certainly.
না না একসঙ্গেই তো আছে
Six. Item number 6.
ওই সুপ্রিম কোর্টের ম্যাটারটা একটু দেবেন তো সুপ্রিম কোর্টের ফাইলটা একটু দিন তো যেটা গেল আগে Glad. Passing it over, call him. I kept it to because he did not want
The
it to
first
be
day he
on that
said
day.
that this is the risk.
Call him. Tell him I'm waiting for him.
Yes, should be.
Password. হ্যাঁ এক মিনিট
Well, inform not today.
7.
not today.
Eight.
Yes, my lord, this is my application. I'm here.
With party, a short pass over, your lordship.
8.
My lord, on the last occasion also did not appear.
Yes, item 8.
So I've got the affidavit of service. May I start and they can come and say whatever I have to say.
Lordship, a short pass over here.
It's an order, quorum non judice, passed by the Consumer Forum, or should I say District Forum, State Forum, I'm sorry, which went up to the National Forum. Thereafter, we have come up here. And your lordship's order is very much there to that extent that this matters can be taken up in view of the Supreme Court decisions. And the Supreme Court has decided on the issue to the extent that we have to go to the jurisdictional court. That's why we are here. It arises out of Calcutta. Now, my lord, I'll take your lordship through the order. Firstly, this matter was heard out by 2-member bench. But when the order was passed, it was only a single member who passed the order. If I may take up this order with your lordship. Yes. Is the penultimate order which has been annexed. It's not numbered, my lord, because cannot be numbered. Kindly seize the order being passed by Honorable Mr. This is, has your lordship got the order?
Yes.
Yes. This is passed by Honorable Mr. Shomresh Prasad Chaudhary. He's a presiding officer. No? There's no page. There's no pagination, my lord, because this is the impugned order. Both the orders are impugned. The National Forum as well as the state one. The maybe the last 8 pages, my lord.
Yes, I have seen it.
Kindly seize the order, my lord. The signature on the order shows Honorable Mr. Shamaresh Prasad Chaudhary, presiding member. There's no second member, but it was heard out by two members. Now, your Lordship knows in terms of Section 16 of the Act, Consumer Protection Act, this is guided by the 1986 Act. And even the present Act, the 2019 Act, speaks of the same thing, that it must be presided by at least two members. If there is an anomaly in the members, if they are not decided, in that case, the third member or the chairman will take up the matter. Now, if I may take your Lordship, only this part I've shown it to your Lordship. Thereafter, I'll show it to Lordship the provision of the Act and, if necessary, the Act itself, because this is a quorum non-judis. There are two books here. Where's the other book? I'll just hand it over. I'm sorry, Milord, I had both the books out here. Oh, thank you. Milord, Section 16. I'm handing up my learned junior friends, Milord. I'm thankful to him. The Consumer Protection Act of 1986. Thank you.
Yes.
Yes. If your Lordship sees the composition, Section 16, the composition of the State Commission. Each State Commission shall consist of a person who is or has been a judge of a High Court appointed by the state government, who shall be a president. Provided that this is not very important, my lord, who are going to be there. One chairman, two persons, members. I do not need to apprise your Lordship on that. Kindly comes to capital 1A, capital 1B. That is interesting. The jurisdiction, powers, and authority of the State Commission may be exercised by the benches thereof. 2. A bench may be constituted by the President with one or more members, as the President may deem fit. One or more members. If the member of the bench differs in opinion, if the members, this is plural, of a bench differ in opinion on any point, the points shall be decided according to the opinion of the majority, if there is a majority, but if the members are equally divided, and they shall state the point or points on which they differ, and make a reference to the President, who shall either hear the point or points himself, or refer the case for hearing on such point or points by one or more of the other members, and such point or points shall be decided according to the opinion of the majority of the members who have heard the case, including those who first heard it. Then comes the salary. Now, my lord, my case is completely different, and it attracts this provision as well as it's different. My matter was heard out by two members. It's not that a single member was hearing it, it was quorum non-judice since initiation. But when the order was passed, it was a single member. Now, your Lordship knows quorum non-judice will have its effect. It is a nullity practically. Now, on this particular part, I'm not taking your Lordship to the order. Do I take your Lordship to the order? There are other points in the, yes, other merits, because this is motion.
This is the point, then in that case, no use getting into the merits of that.
Yes. I'll just come to the decisions if your Lordship so decides. I'll come to the decisions straight away. Malad, what should be the jurisdiction?
Mr. Chaudhary, if it was heard by a bench consisting of two members, how could the order be passed by a single member?
I am wondering how could the matter be heard by two members. This is coming up now. Let us see the appeal, whether this issue was taken before the NCDRC. What is to show that the matter is heard by two members, but one judge passes the order?
Only the presiding member can hear.
Yes, settled law, my lord, and can pass the order. There is a judgment of this honorable court, which is why if I may cite the judgment, my lord.
Malad, should I cite the decisions of the Supreme Court? Yes, let him say.
Lord, this is not the judgment, and then it can consider. Read them out.
No, but there are Supreme Court judgments.
Yes, let us see the Supreme Court judgments. If there is a contrary Supreme Court judgment, it will prevail. But on this hearing issue, your lordship will kindly see, my lord, page 148, which is the appeal before the NCDRC, my lord. There is nothing mentioned in that.
It is there. It is there.
Let us see. In fact,
If
no, let us see the appeal.
Should I cite the decision, my lord?
Yes, yes, please say.
Yes.
Because I have also held that two members bench should be there
In
in state commission. Yes, in revision.
I didn't
Like
find it
3
yesterday.
days back, I rendered.
Oh, that's fine, my lord. But there is also another Supreme Court judgment your lordship may consider, though, my lord, it's not absolutely on the point. Now 96.
Gulzari Lal.
Yes, my lord.
Gulzari Lal.
Gulzari Lal is what I'm going to cite, my lord.
Gulzari Lal I have considered.
No, this is, my lord, Indarmani Kirtipal. This is in an administrative tribunal
Not
matter.
cited, I was not aware of this. Otherwise, I would have dealt with. But I have independently held that it should be two members.
But my mistake, my lord, I did not find your lordship's judgment.
It was delivered, I think, on Monday.
So that's why it hasn't yet come.
My judgments usually don't come.
No, no, your judgment is very much there. The previous judgment for which we filed a writ petition and took it out. 227. I have the judgment.
My lord, please see,
Why
my
should
lord,
it come?
paragraph 2.
Make it come. One judgment.
This is copy down.
But this is
single
some other tribunal.
Yes, yes. Administrative tribunal. My lord, paragraph 2. Question therefore is whether the learned single member of the tribunal was competent to decide the matter. We are of the view that the member had the jurisdiction to decide the matter for the reason that it is not a case of initial lack of jurisdiction. Undoubtedly, the vice chairman of the tribunal by operation of subsection 1 of section 5 has been empowered to classify classes of cases and make sitting arrangements for the benches he has ordered. My lord, then when its members dispose of it out of administrative convenience, it does not relate to jurisdiction. So, my lord, single member, and then since the tribunal consists of several members, a bench consisting of a single member may also be competent.
I think you should consider that also now because this will
And
be now
my lord, I also want your lordship to, my lord, consider
Gulzari Lal.
rule
ওটা ওনাকে ফেরত দিয়ে দিন দুখানা ছিল
rule 7 of
তা আছে ওটা ওনাকে
the
Gulzari Lalটা কোথায় গেল?
at a better. My lord, also kindly see the rules.
Gulzari Lalটা ছিল এখানে কোথায় গেল?
Rule 7.
এটা রাখো, এটা রাখো।
Please come to, my lord, rule 7. My lord, this is now standard. The order can't be affected. Rule 7, sub rule 5.
Yes,
No.
that is there in the section also. I have
Yes.
interpreted that. That is there in section 23 or something.
Yes, 20.
23 something.
My
Which
learned
again-
friend wanted to rely on a Supreme Court. দেখাও না।
Same Gulzari Lal. My lordship has already considered that. The same one.
Zarilal, and there is
Yes, I'll give it to you, lordship.
Cox something was cited.
There's also, my lord, Hindustan Lever Limited was a state consumer redressal
This
forum.
was not cited. Some Cox judgment is there. KOAAKS. I don't exactly recall the name. It had walked up to the Honorable Supreme Court from Rajasthan High Court.
Yes, that matter is, my lord, also Rajasthan High Court's matter. Even I had it.
Most of the judgments on this point are from Rajasthan.
Yes, it's from Rajasthan High Court and held by the Supreme Court also, my lord. Single bench and then to the.
There are two other judgments of the Honorable Supreme Court on the same point saying that no, the single bench will not have jurisdiction. National Commission's order are quashed. Two matters I found referred to in Rajasthan High Court, but since those were not reported, I did not. I found from my own research, those were not cited. This I could not find.
Your lordship said Cox, my lord, C-O-X-X-E.
K-O-K-K-S.
Then your lordship would have to hold this per incurium and proceed.
Supreme Court.
If there is a Supreme Court.
Yes,
decision
yes,
on
it
the
can
point,
be done.
If there
Absolutely.
is a Supreme Court on the point, then I don't need to consider.
Yes.
Yes, why? But, let me consider and come back tomorrow.
My lord, the problem is, my lord, on the 8th, now the proceeding, they're taken out 15 lakhs.
Coming back on Tuesday.
Come back.
My lord, on the 8th, just let me make myself clear, my lord. On the 8th, a warrant has been issued to bring those directors.
No, no, and we are coming on Tuesday, my lord. Next court day, my lord, which is the 7th. I'll come in the
Not only that, 15 lakhs have been taken out.
naturally.
Now 8 lakh, 5 lakhs have to be taken out. I will show the injustice that's been done, my lord.
No, the real injustice is that my client has paid the whole consideration to a developer plus 6 lakhs extra. He has not got possession, he has not got conveyance, and Millard, he's not got refund of those 6 lakhs also.
Not completely true, my lord. I did the completion certificate.
Findings of
Within the
both
time, I told them to take possession. They did not come up with the possession.
findings
said
of
there's
both
difference.
courts are in my favor.
They said there's
And this
difference.
Wasn't taken before NCDRC.
We have taken, we
doesn't
will
mean-
cite it.
No, it's not there in the
But if
appeal.
it goes to the root of jurisdiction, my lord,
Yeah.
it can be taken at
I
any point of
concede,
time.
my learned friend is right. If it is quorum non judice, it goes to the root of the matter. Lord, please keep it high on Tuesday.
Madam, limited stay, my lord. Let it be taken up on Tuesday. If we miss out, my lord, I have to go. My lord, there's a warrant issued against him.
But we are.
And they're proceeding furiously on the
If
issue.
if there is a warrant, Mr. Chaudhary, then they'll be in difficulty for some reason
If there is a warranted, yes, it can be. Give kindly state, my lord, in that case.
Grateful, man.
Yes, I don't want a person to get arrested.
And are the directors of the company.
this revisional application.
Grateful.
पता नहीं क्या पता नहीं बोलूं देखिए बोलूं कि मैं
On the last, I beg to appear on behalf of the petitioner. On the last occasion, your lordship was pleased to grant us liberty to use a supplementary affidavit annexing some certain documents. I have also served them a copy. Your lordship kindly takes this supplementary affidavit. The suit is for eviction. I am the defendant. My 7-2 application has been rejected by the impugned order, and 7-3 has been invoked, and my defense has been struck off. My contention all along was that the plaintiff opposite party was not the landlord. He never informed me that he has purchased the property. There is a letter where I have through my advocate I have asked them whether they are the landlord to inform me, and so that if they are my landlord now, then I can pay them the rent. That is in 2050. In 2017, by an eviction notice, they thereafter initiate the suit for eviction. Now, since I have not admitted them as my landlord, I have not complied with 7-1 and 7-2. And solely on that ground, for non-compliance of 7-1, 7-2, my 7-2 application has been rejected and 7-3 has been invoked. Evidence was laid on this. And if your lordship kindly
yes.
Initially, I filed a 7-1 application because 7-1 application filing it presupposes that I am admitting them to be my landlord. But my 7-1 application was the sole only contention in my 7-1 application was that I have filed a 7-2 application, kindly adjudicates that 7-2 application and thereafter decides. That was my only contention in my 7-1 application. If your lordship kindly sees page 27 of my revisional application. Page 27 of the revisional application, if your lordship kindly sees.
Yes.
There are only 4 paragraphs, your lordship. The plaintiff has brought the present suit by suppressing true facts. Second, the defendant appeared through his advocate that the defendants filed a petition under 7-2 for determination of disputes mentioned in the said petition. That the provisions of 7-2, but as per provisions of 7-2, the defendant is not required to pay or deposit the current rent. That was my contention, and thereafter one may graciously be pleased to take note of the fact that the provisions of 7-2 has duly been complied with. That language I am not saying, but my contention was never that I have admitted the landlord, the opposite party as my landlord. Now, the phrasings of 7-2 is on when the rent is admitted.
Mr. Chatterjee,
Yes.
it is not a question of you not admitting. You have to raise a dispute.
I have raised a dispute in my 7-2 application.
That should be apparent from your application. That
Yes,
you have
in
raised a
7-2,
dispute.
in 7-2.
Staying silent.
No, I have not said
Permission if
this
you
is
have not
7-1. Since the wordings of 7-1 is that when I have admitted
dispute to be raised, you have to raise a dispute.
I have.
You have to dispute the landlord-tenant relationship.
Yes, I have. In 7-2. 7-2, your lordship will find on the very next page, page 28.
Yes.
Paragraph 7, your lordship kindly sees. That there is no relation.
Dispute, right.
Yes, this is my dispute. I have all along maintained this. Now, if by the impugned order, the learned court below has come to a finding somehow that even quoting that I have in my deposition have said that I have not a fact that I have not tendered rent to the plaintiff. after 2014. But from the supplementary affidavit, I have annexed the entire certified copy of the deposition. There is no such statement. There is not a single wording to that effect. If your lordship kindly takes up the, may I just place the impugned order once? The second page, if your lordship kindly takes up, because the first page less than 7.1 has been quoted. From the very first line, the defendant in his application 7.1 did not file any statement about from which month he intends to deposit the area rents and the current rent. Instead, in the said application, he stated that as per provisions of 7.2, the defendant is not required to pay or deposit the current rent, and he further prayed that 7.2 has been duly complied by the defendant. Now, on perusal of defendant's petition under 7.2, it is found that the defendant denied the relationship with the plaintiff and stated that he was a tenant under one Kanuklata Chatterjee at a monthly rent of 165. It is the case of the plaintiff that he purchased the suit shop room of the present defendant by a registered deed of such and such. Therefore, evidence was taken in respect of 7.2 application. On perusal of DW1 dated 21st of December 2019, it is found that he admitted that the plaintiff has filed a suit for eviction and that he has also received an eviction notice dated 27th November 2017 from the plaintiff. He further admitted that he did not pay any rent since after June 2014. He further stated in his deposition that he went to give rent to Chatterjee, but it was not received. He further admitted that he did not send any money order in respect of rent. On perusal of DW1, it is found that he admitted the plaintiff has purchased the suit property by way of deed such and such. He also stated that not a fact that I have never paid rent to the plaintiff after 2014. These two sentences I have never said. That is my contention. The plaintiff of this suit has filed certified copy of the deed. These are marked as exhibits and the notices. Now, may I take your lordship to the supplementary affidavit, my deposition. That is at page, the cross-examination, that is starts at page 1515. The first page is handwritten. From the cross-examination part, your lordship has got it. That affidavit in chief is written as per my instruction. I know the contents of lordship.
My direction. Direction,
As-
not instruction.
As per my instruction, your lordship.
My direction. Read over and explained.
Page 15, your lordship.
1.5. As per my direction, not instruction.
No, I am pressing the cross-examination portion. Lordship.
Oh,
I'm sorry, your lordship.
then it is page 16.
No, page 15, the cross-examination starts. It's
Yes.
just after the first 3 lines, the cross-examination starts.
right.
The affidavit in chief is written as per my instruction. I know the contents of the written statement, not fact that I am tenant in the suit shop under Dinesh Gupta, who is the plaintiff, the opposite party here. I am tenant under Kanuklata Chatterjee. I have not filed documents to show that I am tenant under Kanuklata today. It is fact that monthly rent of suit property is 160. Since June 2014, no one came to receive rent. No money order has been sent by me for rent after June 2014. I cannot say whether my rent was deposited after 2014 or not. I have not deposited due rent to the Office of Rent Control. Thereafter, Kanuklata was the owner of the suit shop. I have heard that Kanuklata Chatterjee is no more in this world. I cannot say the death of Kanuklata Chatterjee. The house of Kanuklata is not far away from the suit premises. I have inquired about death of Kanuklata in her house and had a talk with her daughter, who used to collect rent from us. I cannot say when I went to house of Kanuklata. I cannot say the address of Kanuklata, but she resides at Bhiringi Mode or Bhiringi Gram. Not a fact that I never went to house of Kanuklata, even after hearing the news of death. Not a fact that I do not know the address of Kanuklata. Not a fact that whatever have been informed to me by Maya is totally false. The rent of the suit premises is 160. I have not filed the rent of this
Yes,
suit.
sir. Where did you get that from? Not a fact that I have not paid rent to the plaintiff.
My lord,
Not there anywhere in the cross-examination.
if my lord takes up page, the second last sentence of the page, my lord,
Which page? 16.
my lord, page 16.
Yes.
My lord, it is a fact that since June 2014, I am possessing the suit property without paying rent.
Yes.
As I do not know.
as I do not know to whom to pay
No,
the rent.
what has been quoted by the learned trial court is something else. He says, not a fact that I have never paid rent to the plaintiff after 2014, as if he has paid rent to the plaintiff
Prior
after
to
2014.
2014. Or at least have attempted to pay the rent.
This shows a little non-application of mine.
And
My lord,
another
he has attempted, my lord, I will show that he has attempted to pay rent, my lord. And
That should come from the order. He
My lord,
might have read someone else's brief and passed the order then.
no, my lord will reflect from the order and from the documents only that he has taken.
No, but
he
where's
has
the
taken,
statement? You show me the statement because he has specifically quoted it.
not a fact that I have
It should be
never.
there somewhere for it to be quoted. And he should come to a conclusion that the dispute raised is sham.
Yes.
Or
Only with regard to a sham dispute.
for allowing a section 7.3 application, case has to be strong. It can't be that somebody's real defense is struck off.
That
is
I'll
not the-
that I will try to establish from the documents on record and the evidences laid by
You
the.
have to establish that from the order also.
But for regarding the court,
Ultimately, I may lose.
I'll not appreciate evidence. He'll have to do that. That work has to be done by him.
my lord, regarding the court,
It's not like a court of appeal that I'll reappreciate everything and come to a separate conclusion. You have to show that this conclusion is justified on the basis of what is there on record.
my lord, this
That his
quoting,
defense should be struck off without citing any reason as to why his defense is not entitled to succeed, why the landlord-tenant relationship that he has disputed is not worth naming a dispute.
my lord, if I may, my lord, in that event, my lord, regarding the
Finished.
court.
No, only one more thing may I place. Two things I will place, Your Lordship. From the
before my
supplementary.
learned friend
Just
advances
a
his
minute, I'll keep on putting questions to you so that you give a consolidated reply.
argument.
Yes.
Lordship, from the supplementary affidavit, the evidence of the plaintiff, the opposite party, page 7. If Your Lordship kindly sees the cross-examination. The last two lines of that page.
Page
7. The last two lines of that page. Bablu Mode is the defendant, petitioner.
Yes.
Bablu Mode was in possession of the suit property since my purchase. It cannot be said from the deed that I have purchased the shop of Bablu Mode, but I have purchased the entire area that is mentioned in my deed. So even from going through a bare perusal of the deed, it cannot be ascertained whether my shop room has at all been transferred. And another thing, Your Lordship, there is a letter where my learned advocate has, I've already stated, mentioned in my submission that in 2015 has wrote a letter to the plaintiff. Now that letter I ought to place before Your Lordship the language of that letter at page 17 of this supplementary affidavit.
Your main case in the supplementary only is in the supplementary only.
No, this was annexed to the writ petition, to the revisional application, but Your Lordship, that was a different document. There are several tenants, so another tenant's document came. Your Lordship kindly sees the second paragraph, that my client reports to me that he came to know from one Nimai Gorai that you have purchased the same, but neither landlord of my client nor you ever informed my client till date. So here also I am not admitting him to be my landlord. Next paragraph, that my client states to me that he is ready to pay monthly rent to you. As such, you are requested to supply a copy of the deed or to inform in writing regarding your status over the tenanted shop of my client, and also request you to advise my client or to inform me how my client will pay rent to you. This letter was only given because the plaintiff was also a tenant, was also had a shop room in that same premises. So he was a tenant initially. So whether subsequently he has purchased, because it was not that he came up suddenly, opened a shop room, so I got the information. He was all along there. So whether he has purchased or not, that was not clarified to us. So that was the basis on which this letter was sent, and in my respectful submission, there was no reply to this and nothing has been exhibited. So there is nothing on record to show that they ever informed me that they have now purchased the shop room and they are now claiming rent. That is my humble submission.
My lord, regarding the court which has been stated in the order, my lord, regarding this fact, I need to take some instruction, but not a fact that I have
When is your
never,
next date?
my lord,
Instructions might not
24th
include
of March. 24th of March was there,
24th
but
of March, my lord.
the last date was there, but the next date I am not certain now.
If my lord keeps it day after tomorrow, my lord, I'll come back.
Day after
My lord,
tomorrow, I won't come.
my lord, on Monday, my lord, I'll come back with instruction, my lord.
Monday will be monthly list day. We can have it on 9th or 10th. 10th we can have it.
9th.
7 তারিখ।
এই 10 তারিখ হবে তো?
My lord, 10th, I have some personal difficulty, my lord. Can it be after 15th, my lord?
15th is a holiday. bro.
Can it be after 15th, my lord?
When is the next date then? I don't want
I have
him to be in
to,
trouble unnecessarily.
Lordship,
He has
kindly
good
keeps
case
it-
and then he'll go
Kindly
for-
kindly stays for a limited period, end of
Kindly keeps
April,
it
if your
anytime
lordship.
next week, my lord. Anytime next week other than 10th, my lord.
17th, 10th এগুলো ফ্রাইডে, এগুলো স্পেশালি ফিক্সড ম্যাটার গুলো, স্পেশালি অ্যাসাইন ম্যাটার গুলো যদি থাকে তাহলে অসুবিধা হবে, রাখা যাবে না। 22nd,
My lord.
22nd. This revisional application appeals and order dated February 24, 2026, whereby the petitioner's application under section 7(1) and 7(2) of the West Bengal Premises Tenancy Act, 1997, have been dismissed, and the petitioner's defense has been struck off by invoking the provisions of section 7 within bracket 3 of the 1997 Act. Stop. Paragraph. Heard learned advocates appearing for the respective parties, full stop, as prayed for by Mr. Chaudhary, learned advocate, appearing for the opposite party, list this matter once again on April 22, 2026.
Lordship, in the event the next date is within this period, may I pray for an adjournment? Only that may be
लिखे नहीं।
indicated.
In case, comma, the proceedings before the learned trial court are fixed prior to the returnable date, comma, the parties, the petitioner shall be entitled to pray for an adjournment before the learned trial court.
I'm grateful. Your Lordship. And supplementary affidavit may be kept with the record.
একদম উপরে লিখে দিন। Supplementary affidavit filed in court today is taken on record. A copy thereof has already been served on the learned advocate appearing for the opposite party.
Yes, yes. Upon grateful, Your Lordship.
Item 10, my lord, I beg to appear for the petitioner. Lord, in essence, this civil revision application is an expeditious disposal of a receiver application filed before the commercial court. And I,
Pending since long.
no, what has happened, my lord? Suit for eviction, my lord, a judgment of admission was initially passed. Against that, they had assailed it. My lord, the honorable division bench had allowed the appeal and had directed them to pay rupees 3 lakhs per month as occupational charge. But initially, they had paid for 2 months. Since after that 2 months, my lord, they didn't pay, my lord. Now, they came up and they had submitted before the learned court that they are not in possession of the property. Now, the third parties are coming and settling in the property. My lord, that is the exact reason we had preferred an application for receiver. Now, that receiver application, my lord, could not be taken up due to this ongoing SIR exercise.
Can be taken up. It can be taken up now. I'll direct expeditiously.
Yes, your lordship would kindly take the order dated February 2, 2026.
My lord,
Your Lordship would kindly record their submission that they have vacated the
I have
property.
recorded that. I recorded. আছে না ওখানে সমর বাবু রেকর্ড করলাম না they have vacated that they have vacated the suit premises.
Yes, yes.
Item number 11.
I am for the
Yes, Mr.
petitioner, my lord. Though there was no direction, my lord, I have, my lord, been able to persuade the client to, my lord, bring the check itself. my lord.
Should bring.
May I kindly records the number of the check, my lord, and my lord, records that it has been handed over on the board.
I'll state you after this. You come prepared, or you are prepared today. You can proceed.
My lord would direct us to file affidavits.
Affidavits. CO the affidavits.
Affidavit, what you'll file? Law point. Come
Everything
prepared.
is there. Two,
My lord says so.
two courts, my lord. Forums, not courts.
This revisional application assails an order dated
My lord, may I, my lord, I'm sorry for the interruption, my lord. My lord, I pray that my lord kindly gives us the direction to file a short affidavit within a week, my lord. We shall come back.
Fine.
My lord, there are certain points.
this revisional application lays challenge to an order dated January 30, 2026 passed by the learned civil judge within bracket junior division, Bidhan Nagar, North 24 Parganas in miscellaneous suit number 13 of 2024. Full stop. The aforesaid case is actually an appeal under section 146 within bracket B of
14.
the 6B, 14 within bracket 6 within bracket B of the West Bengal Shops and Establishments Act, 1963, preferred against an order dated January 29, 2024, passed by the referee under section 14 within bracket 3 of the 1963 Act. Full stop. Paragraph. By the order impugned, the appellate authority has directed the petitioner to pay a sum of rupees 27,176 as salary for the period of 27 days for the month of May 2022, together with rupees 78,510 as 3 months notice pay, aggregating to rupees 1,05,686 to the opposite party. Full stop. Paragraph. The aforesaid sum has been doubled and a total sum of rupees 2,11,372 has been directed to be paid by the petitioner to the opposite party upon invoking the provisions of what is that compensation provision
14.3
of section 14 within bracket 3 of the 1963 Act. Full stop. Paragraph. Mr. Lahiri, learned senior advocate appearing for the petitioner, submits that since the opposite party was a probationer in the was a probationer in service under the petitioner, payments agreed to be made to the opposite party could not be treated as wages in terms of the 1963 Act. And that being so, the direction of payment as made by the learned referee and affirmed by the appellate authority under section 14 within bracket 6 within bracket B of the 1963 Act suffers from material irregularity and illegality. Full stop. Paragraph.
May I take leave, ma'am?
Yes.
So my junior is there, my lord. He will.
Yes. Mr. Sarkar.
Well, in this matter, Mr. Somnath Chakraborty is appearing for the petitioner. He has not come to the court because of personal duty. I am printed, not to.
Next.
Your Lordship, I am as in person as an appellant because already I have filed under CPC 104 bracket 1 bracket FFA. This appeal which has been filed before the City Civil Court, Calcutta. And this final hearing which has been already conducted by the petitioner as well as by the defendant, but they have filed two adjournments without completing their arguments. And it is supposed to play a vital role because the case is dragging from 2020 onwards.
What is the case before the city court?
Before the city court, it was already the first order which has been passed by the small cause court, bench number 2
Eviction order.
for eviction. But it
you are
has
supplying
gone
the order.
against me. It has gone against me because under 14.
You have preferred appeal against that order.
Yes,
That appeal is
yes.
pending.
That is pending.
You want expeditious disposal of the
Your
appeal.
lordship, your lordship. I have done.
लिखे नहीं तो none
in and around August 2015. And thereafter, my lord, basically here I am challenging the two orders dated 13 November 2025 and 24th December 2025. And along with, I am also praying for, I'm led by my learned senior. And along with, I am also praying for expeditious disposal of the suit. My lord, the matter is, as I was telling you, I filed this application in the year 2015. And thereafter, my lord, in between, sometime in 2023, I have also applied in the High Court, in this Honorable Court for revisional application, praying for expeditious disposal of the suit. This Honorable Court, after hearing by an order dated January 2, 2023, which I have also annexed the order at page 23. And this Honorable Court directed disposal of this matter within Puja vacation of 2023. And thereafter, my lord, if your lordship goes through page 26, where I have also annexed the order dated 24th Jan 2023, the learned court below has observed that it is not possible for the parties to lead their conjugal life jointly.
Very well.
And
you want expeditious disposal of section 24. Because of that, your suit is stayed.
I'll just tell your lordship in a nutshell. I would have normally just prayed for expeditious disposal, matter would have ended. Now what has happened is, your lordship has seen the order directing disposal in September. They have consistently been taking time after that. At that point, there was a 24 application already pending. Learned judge called for the husband and wife, spoke to them, found that there was no possibility of restitution. So said, the decree for divorce is imminent. take steps to file a 25. They said, yes, we intend to file a 25, we will withdraw the 24. They withdraw it. Thereafter, I get into the box, my chief is completed. They keep taking time, my lord, to cross. Finally, the learned judge gets fed up, fixes 3 consecutive dates as a last chance that you complete cross within these 3 days. Because now we are in 2025 November. First day, they come file a fresh 24. In the meantime, the pending 24 has been dismissed as not pressed because they take out a 25. First day, they withdraw their 24. Next day, I come with my written objection. First day of the 3 consecutive days, they file a 24. Next day, I come with my written objection, they withdraw it. The third day, they come with a fresh 24. At that stage, I pray that my cross-examination be closed and that the matter be, the decree for divorce be passed 25, whatever permanent alimony they are entitled to. That will be decided before, after, whatever. It is immaterial. The judge says that no, nothing doing. My application is rejected. Their 24 is directed to be taken up sometime in February, and my suit is kept pending. Till such time that the 24 is decided. Last date was 10th of February. I've taken instructions. Nothing has happened on that. Possibly due to SIR. But as
how many Section 24 applications had been filed?
When this earlier 227 order was passed, there was one pending then. That was withdrawn sometime in 2024. Thereafter, fresh 25 filed in November 11th. 25 or 24, sorry. 24 fresh filed in November 11th, withdrawn November 12th, another 24 on November 3rd.
Third in line.
This is the third in point of time, and there is a 25 already pending.
This revisional application seeks expeditious disposal of matrimonial suit number 153 of 2015 pending before the learned additional principal judge, family court, Calcutta. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that the opposite party has been instrumental in dragging the suit by filing successive applications praying for alimony pendentility under Section 24 of the Hindu Marriage Act, 1955, and then withdrawing the same. Full stop. It is submitted that initially an application under Section 24 of the 1955 Act was filed on
the date of filing. I'll just tell your lordship. It was dismissed. I have the date. It is at page 55 on 10th of July 2024, the first one.
It is submitted that when was the latest one filed?
My latest one was filed on 13th of November 2025.
That, on November 13, 2025, and that the application which was filed, the application under Section 24 of the 1955 Act, which was filed on November 13, 2025, is the third in line. Full stop. The same was filed at a time when cross-examination of the petitioner's witnesses was closed.
No, was ongoing.
Was going on. Full stop. In the garb of pendency of the said application for alimony pendentility, the petitioner's suit itself has been stalled. Full stop. Paragraph. একটা usual paragraph থাকে বলে দিচ্ছি লিখে নিন having regard to the nature of the order proposed to be passed, no direction for prior service of a copy of the revisional application along with notice on the opposite party is being made, however, the petitioner shall remain obliged to serve a copy of the revisional application along with this order on the opposite party within a week from date. ঠিক আছে? তারপরে week from date. Full stop. Paragraph. Having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned additional principal judge, family court, Calcutta, to dispose of the opposite party's application under Section 24 of the said Act of 1955 as expeditiously as possible and preferably, when is the next date fixed?
The next date,
Preferably
well, when we had filed,
within a period of, you have filed your written objection to that?
to the 24, well, possibly. I don't have instructions.
Preferably within a period of 3 months from the next date fixed, full stop. The learned trial court shall thereafter and there shall na kore is requested to thereafter take up the suit and dispose of the same as expeditiously as possible, and preferably within a period of 8 months from the date of disposal of the application under section 24 of the said act of 1955, without granting any unnecessary adjournment to either of the parties.
Usually, your lordships use a very tempered language.
Okay.
Your Lordship asked me, yes. Your Lordship asked me that there is no relation with these documents. So my application has been filed. Order 18, Rule 17, application is para 18, 8 para, page 8. Your petitioner states that as per order 18, 17 of the Code of Civil Procedure, the court may at any stage of the suit recall
That's
any
right.
witness
It is
at any time.
it is the power of the court, not the right of the party. So you cannot claim it as a matter of
But
right.
on
If
that
the
on
court
that point,
feels
Madam,
that
I
it
am
needs to
placing on
exercise-
judgment of the Supreme Court that when 17 of the
Didi.
Supreme Court said, Madam, at any time, my lord, para 8, very important. Para 8, I have said in this decision, my lord, already said, Madam. 18 and 17 can exercise by the court either on own motion or in an application filed by any of the parties to the suit requesting the court to exercise the said power.
Thereafter, that sentence is important. Please read that.
The power of the discriminatory and
the power is discretionary and should be used sparingly in appropriate cases to enable the court to clarify any doubt that it may have in regard to the evidence led by the parties. This is exactly what has been negated in your court. In your case, the court says that this has no relevance, and it has mentioned why it has no relevance. The evidence which you want to bring on record pertain to different DAG numbers than those which are mentioned in your suit.
Yes.
So that is why, how can I find illegality in the order?
Lord, in this matter, my lord, the documents are not available. Document not may not be connected. That is not.
The court is not doubting the reason for you
But at this
producing
stage,
it
my
late.
lord,
The
but
court
at
is
this,
saying it has no relevance.
but when the issue will be filed, at the time of filing the issue, they raise the question, my lord.
That the plot of land with which the suit is concerned, that is not the plot of land in relation to which you are citing evidence. How is it relevance? This revisional application.
I appear for the caveator.
17, Lordship, I appear for the petitioner. Lordship, there is a similar matter. They have challenged against the same order that is appearing as
46.
item 46.
I'm releasing both of them. Didi, 46 টা আর এইটা দুটোই রিলিজ। This matter stands released from my list, from this list on my personal grounds. Let this matter be placed before the Honorable, the Chief Justice for appropriate orders. The same order ta
46.
Lordship, can it be,
46 same order.
Lordship, can it be, both the matters can be tagged together by your Lordship?
It's both of them, since they are being released today itself, I think they'll be assigned before the same bench.
In a copy to the
রিলিজ করলাম, দুটোই রিলিজ, দেখে কি করবে?
May I please, Lordship? My Lord, later administration proceedings, I am the contesting defendants. I appear and file reaching objects that the Anastas C, page 18. And previous learned advocate made an application that we did not get any summons from the trial court. So kindly allow me to contest the proceedings. Along with reaching objections, my Lord, learned trial just directed me, and you have to pay cost, which is 300. My Lord, that 300 cost was not paid by the petitioner. Vishwajit Dasgupta, he went on surgery, went to Chennai hospital. Because of that reason, cost was not paid. Newly engaged advocate made an application on 18 March. Kindly allow me to pay the cost and contest the proceedings. Learned trial court says no, that cannot. Later administration, I have made so many applications to serve a copy upon the will. Still now, copy of the will has not been served. And by the impugned order, though the order impugned, first line says the 10th March 2025, petition is 18 March 2025 was taken up for hearing. March petition, that is page 23. Learned trial court took cognizance that the earlier order for payment of cost was not paid by you on compliance, non-compliance of court's order.
Mr. Ghosh, the recordings are.
This is not correct. Learned trial court committed a mistake.
I mean, time was sought for on the ground of surgery of the learned advocate. The same learned advocate kept on representing.
That may be wrong. And earlier, Vishwajit Dasgupta subsequently summoned the course.
But he records that the same learned advocate was representing all the time.
Kindly turn to page 23. That is 18 March applications, paragraph 2. 18 March application, page 23. Annexure D. I may be permitted to read out the paragraph 2 of the applications, 18 March. 21st September 2024, OP filed written objection which put a petition before the learned court. Learned court pleased to pass an order against the office to payment of cost 300. Senior Mr. Vijay on behalf of the OP has undergone heart surgery, severe heart surgery. That is the reason assigned by these applications.
Yes, that he has noted, but he says that he only has represented. That is the recording.
Represented.
Yes, kindly see the last paragraph of the impugned order.
That is wrong.
I can't say that because if it is recording in the order, that is to be treated as correct. There is a presumption.
But the application is otherwise.
Application, he has taken note of that. He says so. On the same date, considering the conduct of the opposite party, this was again fixed on the same date.
May I permit you something? 21st September 2024, Vishwa Dasgupta was engaged. He filed an application permitting him to contest the proceedings. 21st September 2024, Vishwa Dasgupta was the conducting advocate of the opposite party, undisputed. But thereafter, when he went heart surgery, the client felt otherwise. What is the fate of the case? Because the illiterate widow. He appointed HON'BLE subsequently, and he made an application on 26 July 2025. Earlier advocate Vishwa Dasgupta went heart surgery. That is the punishment given to the opposite party. Non-payment cost 300, and he made an application, page 25.
When is the next date fixed?
Next date fixed in 29th April for ex parte hearing of the missed case.
Serve and come before that. This revisional application is directed against an order dated January 30, 2026, passed by the learned civil judge within bracket junior division, first court, Barakpur, North 24 Parganas, whereby the petitioner's application where is that application?
Well, at 18 March applications, that is
10th March.
That is 18 March. That is the wrong.
March.
18 March, it will, Lordship is fine from
page?
Page 23.
Page 23. Petitioners.
Both are similar matter, my lord. My lord, I am just praying for a not today, my lord. As Mr. Rudronil Days will be arguing in this matter, my lord.
19 and 22 not today.
Yeah, I don't mind whether this is preemption final proceedings. We are the caveat. We are proceeding without the.
My lord, kindly take up the matter on Tuesday, my lord.
এমনিতেই দেখুন যেরকম থাকবে not today করে রেখে দিন যেরকম থাকবে. Next.
My lord, we'll take the matter on Tuesday.
That I don't know. Today it is not today.
Lord,
grateful.
Only this has to be taken up together. Will not
yes,
same
Lord.
Both have been made not today, so both will be taken up together whenever it is taken up. Unless if it is not taken up, you remind
We
us
will remind your lordship.
so that the other one comes up.
Very
grateful, lordship. Grateful.
My lord, I am appealing for the petitioner. The petitioner is the plaintiff before the learned court below in a suit for permanent injunction. My lord, the petitioner filed an application under Order 26, Rule 9 for local investigation that was rejected. The civil revision is against the order of rejection of the Order 26, Rule 9 application. The petitioner filed the suit for permanent injunction against the defendants primarily on the ground that the defendants are illegally using and using the name of the property for football match and something, so that say they could not do that, this suit was filed. Well, during proceeding of the suit, the defendants moved an application under Order 39, Rule 7 for local inspection. That was allowed. And after that, from the commission of the local inspection and the proceeding, the plaintiff, the defendants claimed that they are using the suit land since long. Well, I am consistently saying that is incorrect. That is why this Order 26 Rule 9 was filed to ascertain whether they are at all inside the suit property or not. They are claiming that we are inside the suit property. And as such, this Order 26 Rule 9 was necessitated. But the learned court below, in the impugn order, observed that I am trying to substitute the role of evidence in the suit. That is not correct, my lord. I have specifically prayed whether they are included in the suit property or not. That has to be seen by the learned commissioner. For that, this application was filed.
Your plaint contains a prayer for recovery of possession.
No, no, my lord.
Then how?
I am saying this. I am owner of the property. I am in possession. My lord,
if there is encroachment and you don't pray
no,
for
my lord,
recovery of
that is what they are claiming. I am contesting that. The defendants are claiming that they are possessing the land since long. But my consistent contention is that they're not in the suit property.
So
They are trying to organize.
That is a question of possession that you have to prove by your
No, my lord,
pleading evidence.
My lord, by my order.
In possession of the suit property is a question of
Yes, my lord.
evidence.
I am not on possession, my lord. On possession, I am not moving the application. Only on the thing that if they are at all on the suit land or not. They are claiming.
Question is of possession only. Whether they are on the suit land or not is a question of possession only.
Yes, my lord. That their claim came
you are
on
on the suit land, that means you are in possession of the suit land. If
My
they
lord,
are on the suit land, that means they are in possession of
they are
the
saying,
so
my
it's a
lord.
question of
That
possession.
is their claim. I am still
So that is
contending.
why that is a question of possession. Where is the mistake in the order impugned?
My lord kindly takes up the my application. It is starting from page 33, and the points I wanted the learned commissioner to address. Page 34, my lord.
The specific area, if any, by whom dispossessed by the defendant. This is a question of
Well,
possession.
if I am dispossessed, my lord, I have
The question of
different
possession.
recourse, my lord.
That is your prayer. You've said dispossessed. See,
My lord, all the my lord, very truthfully speaking, maybe not all the points can be addressed at this stage, but some points can be addressed by the local investigation. The learned could have decided that. That is my contention, my lord. I am not at all on that possession has to be decided. I'm still contending that I am in possession. My lord, if something is found, then I have different recourse. I understand, my lord. I'll take that. But at this moment,
then your plaint does not contain anything as
Well,
regards encroachment.
that is for permanent injunction. My lord kindly takes up my plaint.
So if your pleadings are not there, on what basis will
My lord, my pleadings are not there because this claim came after filing of my plaint.
You should have amended the plaint then.
Well, they have filed the Order 39, Rule 7. My lord kindly takes up their application.
You are not getting the court's query at all. If you have to file an application for local investigation or even local inspection, there has to be a basis in the pleadings first. It cannot be made in the air. It cannot be made on the basis of someone else's pleading. If your pleading is deficient, correct the pleading and then make the application.
My lord, the difficulty is, it is their claim.
Up to you.
On the basis of their claim, I cannot amend that. My lord, they are saying that we are in
So
possession.
how are you bothered about it? If it is their pleading, it is your suit. Their pleading is not going to
My,
defeat your
if,
suit.
if my lord kindly takes up my prayer in the suit, page 11 is the plaint, my lord. And the prayer is at page 16. Well, the entire premise of the suit is they are trying to conduct some football match in the locality on my property. And that's what I tried to stop. That a decree be passed in favor of the plaintiff, restraining the defendant.
Your application is therefore vague.
Yes, my lord. My lord,
Absolutely vague. There is no mistake in the order impugned.
my lord, the mistake is that their order 39 rule 7 was allowed.
So what? That is why your
My
order
lord kindly
36 rule 9 should be allowed. Because they have got an order. No. Next.
21, my lord, I am for the petitioner, my lord. By this application, I am praying for expedite hearing of the title suit of 2012 pending before the learned civil judge.
You are the plaintiff?
No, my lord, I am the defendant. Plaintiff are enjoying the status quo order, my lord.
Suit for petition?
No, my lord, suit for title and for permanent injunction.
This revisional application seeks expeditious disposal of title suit number 213 of 2012 pending before the learned civil judge within bracket junior division, comma third court, comma Midnapur. Full stop, paragraph. Learned advocate appearing for the petitioner submits that in the said suit, comma, the opposite parties as plaintiffs have been granted an order of status quo which is operating
dated 10th May 2013
on May 10, 2013, which has been operating harshly against the petitioners. Full stop, paragraph. Usual paragraph থাকবে তারপরে having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket junior division, comma third court, comma Paschim Mednipur to dispose of title suit number 213 of 2012 as expeditiously as possible and preferably within a period of 1 year from the next date fixed without granting any unnecessary adjournment to either of the parties. Next.
Lordship, most humbly I beg to appear on behalf of the
Yesterday you wanted that.
It's expeditious disposal.
2024
At 24, my lord, Mr. Raut is appearing, my lord, but due to suddenly he has not come to today. Only not today.
Not today.
Only Monday. Monday. Grateful.
No, I'm for the petition. Yes. No, this is an application for expeditious hearing of the title suit, my lord, 223 of 2011, my lord, pending in the Court of Civil Judge Junior Division, Bidhannagar, my lord. My lord, suit is of the year 2011, my lord. Issues was framed, my lord, on 18/6/2000.
This revisional application seeks expeditious disposal of title suit number 223 of 2011, pending before the learned civil judge within bracket junior division, Bidhannagar, not 24 Parganas. Full stop. What is the stage?
My lord, this is a preemptory hearing stage. My lord, one application is pending filed by the plaintiff petitioner that the defendant, my lord, take some illegal construction, my lord. That's why I filed down my application under section 155-51 of the CPC. Well, that was also pending.
Usual having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting. আচ্ছা ওখানে এনার সাবমিশন এক জায়গায় লিখে নিন তার আগে learned advocate appearing for the petitioner submits that in the said suit, an application under section 151.
Yes, my lord.
An application under section 151 has been filed praying for certain orders. Full stop. The said application has also been pending since.
My lord, it was filed by 16/11/2022, my lord. This application.
Since November 16, 2022. Full stop. Tarpore usual paragraph. Tarpore, having heard the learned advocate appearing for the petitioner and having perused the material on record, this revisional application is disposed of by requesting the learned civil judge, junior division, Bidhannagar, district not 24 Parganas, to dispose of the application under section 151 of the Code of Civil Procedure, together with the application under Order 39 Rule 4 of the Code, as expeditiously as possible and preferably within a period of 3 months from the next date fixed, without granting any unnecessary adjournment to either of the parties. Thereafter, the learned trial court is requested to take up the suit for expeditious disposal and dispose of title suit number 223 of 2011 as expeditiously as possible and preferably within a period of
6 months, my lord.
8 months from the date of disposal of the aforesaid applications.
uh, 26.
Lordship, this is my petition for expeditious hearing. Lordship, I am the assignee.
Expeditious disposal of a suit.
Of the suit as well as your Lordship with a connected petition. This Order 22 Rule 10 is pending. So I am waiting to be added as a party to the suit, Lordship.
Then how can you pray for expeditious disposal before being added as a party to the suit?
Lordship, then let that be heard, Lordship. That Order 22 Rule 10.
How will we file this application then? You are not a party to the suit.
Lordship, since the adjudication is pending, so the suit remains pending.
Divisional application for expeditious disposal of an application under Order 22 Rule 10 filed by the petitioner who claims to be the assignee, the assignee of the plaintiffs.
Lordship, of the plaintiffs.
Full stop. Paragraph. Learned advocate appearing for the petitioner submits that the aforesaid application has been pending since
Lordship, 2019.
2019. Full stop. Paragraph.
Huh?
Usual paragraph.
No, no, it's cannot.
Therefore, having heard the learned advocate appearing for the petitioner and having perused the material of the court, this revisional application is disposed of
अच्छा बोले दीजिए.
by requesting the learned civil judge within bracket senior division, comma first court at Kamluk, comma district Purvo Mednipur to
And it's
27.
27, my lord, I am appearing on behalf of the dependent petitioner. Suit for eviction. My lord, the petitioner, defendant, my lord, appeared in the said suit, filed his written statement along with an application under section 7(2) of the West Bengal Premises Tenancy Act. My lord, that application was rejected, my lord. Not rejected, my lord. That application was allowed, and challenging the same said order, I have come before your lordship.
you don't want it to be allowed.
Yes,
You are the defendant.
I am the defendant.
So,
But calculation rate of rain. And my lord, I am inviting your lordship, kindly come to the order in view.
yes.
Well, facts of the case is that the defendant was inducted as tenant under the plaintiff, and rent was fixed ₹600 per month. My lord, thereafter, my lord, the plaintiff wanted to sell the property to the defendant. Accordingly, one verbal agreement was made between the plaintiff and defendant, and it was settled the consideration amount of ₹1,70,000. Accordingly, the defendant paid ₹1,55,000 part by part. Well, thereafter, it was also settled that the rate of rent need not be paid. Because of that, the huge amount, maximum amount was paid, and the rate of interest of that advance amount is much of the rent. My lord, if your lord, and it is admitted that the plaintiff received the said amount. I have annexed that receipt. My lord, thereafter, my lord, if your lordship kindly come to the order in view. First, second, third paragraph, my lord. In this regard, got it, my lord? In this regard, the plea of the defendant is that it was settled between the parties that as the defendant going to purchase the suit property and already he has paid a huge amount of advance, so he need not pay any amount of rent month by month, as the interest of the said advance money is more than the monthly rent, and the said amount will be treated as rent month by month, and thus the defendant will never be treated as defaulter for any month of tenancy. Now, whether any such agreement was entered into between the parties to purchase the suit property, it cannot be decided at this stage, it is a matter of trial. But now, on perusal of the document filed by the defendant, it appears that he has failed to submit any receipt showing payment of rent from June 2003 to March 2025. As such, the defendant is held to be a defaulter in payment of rent in respect of the suit property at the rate of rent of ₹600 from June 2003 to March 2025. The defendant is, next page, my lord. The defendant is depositing rent under section 7(1) of the West Bengal Premises Tenancy Act since April 2025 at a monthly rate of ₹600. The total rent for the month that he has fallen due is 262 months, June 2003 to March 2025. The rate of rent is rupees 600 per month. So the principal rent is rupees 1,57,200.
Yes, so what is the mistake here? He has said.
Mistake is that, my lord, thereafter, the next paragraph, my lord, the rate of interest, my lord,
10%.
principal amount 1,57,200. Interest, my lord, 1,72,265. And the admitted advance amount which the plaintiff received from the defendant, that has not been
Where is
reflected.
the admitted advance amount? Show me.
I am inviting your lordship, kindly come to the plain, running page 16, paragraph number 2 of the plain.
Yes.
My lord, that paragraph number, the plaintiff, being a owner of the A schedule property, inducted the defendant as a monthly previous tenant in respect of 2 rooms, kitchen, and separate bath and privy, with user of well situated at the ground floor of the 1-storied building, holding number such and such, more fully described in the schedule B herein below, and herein after referred to the suit premises at a monthly rental of rupees 1,500, only payable according to in this calendar month, on payment of rupees 1,25,000 as advanced by the defendant to the plaintiff. That is admitted amount. That has not been reflected in the order impute. Not only that, my lord, the rate of rent is rupees 1,57,200, and the interest, my lord, 1,72,265.
This revisional application.
28.
Madam, this is my application for expeditious disposal of the title suit, my lord, pending before the learned civil judge senior division, fourth court at Alipur, my lord.
Item number 29, I am praying for not today.
30.
Particularly happy for the petitioner, expeditious disposal of suit for declaration and permanent injunction. Suit was instituted in the year 2025.
2025.
Yes. Thereafter, Order 13 and Rule 1 and 2 granted in favor of the plaintiffs and the defendant. Order 13 and Rule 7 granted in favor of the plaintiffs. Thereafter, they have prayed for amendment of plaintiff.
That they are entitled to. Why? I'll not fix any time frame. 2025 suit what?
I did too. But I'm for the petitioner. But this is my application for quashing a proceedings initiated by the maintenance tribunal. But I am the daughter-in-law. I do not reside at my matrimonial house. And my mother-in-law has made an application. Your Lordship, kindly see the page 36 of the proceedings. My Lord, daughter, page 36 of my petition.
Yes.
My Lord, next page is the complaint made by my mother-in-law. But our Honorable High Court and Honorable High Court at Calcutta has held that the daughter-in-law, she does not come within the definition of relative under the Maintenance and Welfare of Parents and Senior Citizens Act
Show me
2007.
the judgment which is said to have. देखी दीदी ओटा.
And we see, my Lord, section 4, subsection 4 and section 2G.
Filed against you as the you are the
daughter-in-law, and I do not reside with my matrimonial house. There is a matrimonial case pending with my husband. Oh.
Very well.
It is totally without jurisdiction. But this is the judgment of our High Court. Paragraph 42, my Lord, kindly see. And another is, my Lord, Honorable Division Bench of Kerala High Court.
Calcutta
page
Court is
10.
there. Kerala may not be required. Give it.
Not same point, my Lord.
I have your lordship's leave to mention a matter, lordship, item number 44. Lordship, this is for expeditious disposal of the surface application pending before Death Recovery Tribunal.
But you have a remedy before DRAT. Why don't you go there? For expeditious disposals, you can go to DRAT.
Lordship, it is only for direction of hearing, Lordship. Otherwise,
that DRAT has power.
Lordship,
There is
if I go before
provision there.
DRAT, Lordship, if I go before DRAT for this, I'll have to pay.
No. That is only if you go
50%.
in appeal under section 18. There is a provision for expeditious disposal. Specific provision is there. Surface applications, DRAT has power.
Second half in 33. সোমবার না সেকেন্ড হাফ সেটাই
এই ডিআরটি একটা নেই এর ভেতরে রিকভারি অফ ডেটস ডিউ টু ব্যাংকস এন্ড ব্যাংক্রাপসি অ্যাক্ট শুধু সারফেসই আছে তো ডিআরটির পাওয়ার ওখানে আছে there is a specific you consider and come file it, it will appear in the list. No unlisted thing.
The very next matter, my lord, it's my lord, possibly from 2 o'clock, my lord is taking another heading, my lord. So, my lord, it's a motion. There's that injunction in where, my lord, despite so possibly now on Monday is a monthly list day, may it have some precedence, my lord. Then very next matter. I don't think it will be called today.
These will remain as new motions only.
As new motion, my lord, then some precedence, my lord.
Lordship will
My
take
lord,
up.
with 109, my lord, is the other matter connected, which is under the heading which will be taken up, but that is being taken up from 79 onwards. That is also arising out of the same suit.
But is it not fixed on 6th only?
But then we all know what will happen, my lord.
We will press our revision, whatever may be the outcome. Whatever, well, we have tried enough. And we will try to satisfy my lord on law and fact. Our only fear is that tomorrow, Monday with the monthly list. So monthly list, it will just
No,
disappear.
if I don't know yet what the monthly list will look like. If in any case on Monday it is not taken up, Tuesday these matters will be at the top, with your matter being at the top. So it will be taken up if not on Monday, on Tuesday.
Great.
Sir, please file it. It will. No. It is not there in the list. I cannot take it, sir. That is not how I proceed.
Lordship,
Item 35.
Item number 34, this will be again posted on Tuesday. Our Lordship will take it up in the second.
My lord, item 35.
Not on Monday. It will be taken up on Tuesday.
My lord, item 35, my lord, early disposal. Very innovative.
Question of law that cannot proceed.
Item number 79.
But I beg to appear for the petitioner. Defendant is the petitioner with your lordship. My lord, on 2 occasions they didn't appear, my lord. And there is an order of stay that has expired. And may I place my case, my lord? My lord, by dint of the order impugned, the learned court, suo motu, has appointed an accounts commissioner after the closure of evidence of both sides. Now, suit for accounts. Now, my first submission, my lord, this could not have been done after the closure of evidence because I will lose the valuable right in case something new comes up. That is my first case before your lordship. And second, my lord, who has been appointed as an...
See, the commissioner's report will also be a piece of evidence. So it will not be taken as sacrosanct unless you get a right to cross-examine the commissioner.
Yes.
So it's not that you will be losing a right even after closure of evidence. If that has been, that procedure will have to be undergone once again.
Yes, but of course, I will get a right to cross-examine. But if something new comes...
Challenge the report as well.
Yes, I have to challenge that report. But I will not get any chance to give my evidence because the evidence has already been closed on my side. That's my case.
We can permit. That we can permit.
That's one part. Second part, my lord, who has been appointed? My lord, an advocate has been appointed. In my respectful submission, my lord, an advocate is not an expert in accounts.
That is a more important part.
Yes, that's more, and that is exactly the civil revision why it was admitted, my lord.
Yeah, first part can be dealt with. That,
yeah, that can be dealt with, but
we can always provide for it so that the
yes, if there is a right,
the principles are followed.
Yes.
But this part, whether he'll be able to execute the work for which he has been appointed, is something which
yes, and
goes to the root of the matter.
My lord, an advocate has been appointed. My lord, in my respectful submission, he is not an expert. She is not an expert. Your lordship would kindly take the order impugned once.
Yes, examination of relevant accounts and all, it will require.
Yes, an accounting, a person of, only someone from the district treasury can be appointed. And another thing, my lord, I must point out, my lord, the learned court has directed, kindly takes the direction A, 2A. Examine all relevant accounts, voucher bills, all relevant accounts. My lord, my respectful submission, only the evidence that was tendered by the plaintiff, that ought to be considered. Otherwise, my lord, he will go beyond the scope. My lord, this is also, my lord, an erroneous finding, my lord.
Why are they not appearing? You have served them.
Yes, they appeared on the earlier occasion also. They took
But there is no recording that somebody appeared on their behalf. The time was sought for on your behalf. Yes, somebody appeared. Opposite party number 1, Mr. Amit Ranjan Pati.
Yes, they appeared, my lord, on the earlier occasion. I was personally present, my lord. They had sought for an adjournment.
None appears for the opposite parties. What will go?
But there is a stay order. They have obtained a stay order. For the execution, and the
Stay has gone. That
Stay
is
has
why they
gone.
wanted this.
I can produce that order also. That stay has gone.
My lord,
I am not enjoying any stay.
again he will repeat the process because
process? The
because
misappeal
he will file
This misappeal will be heard.
this misappeal will be heard. There will be again an order of stay
I
by
am not
pending.
enjoying any stay at that point of time.
Yes,
Not
there was an order of
That is
stay that
all.
was vacated due to their fault.
Yes.
Due to their fault,
That's
they
why
are doing fault in one way and taking a point in another way. They kept it pending for so long and they proceeded with the title appeal. They preferred an application before this honorable court. My Lord Justice Bhattacharya directed section 5 to be heard. That section 5 was allowed. Stay was there. Subsequent to stay, there was an occupational charge that they have failed to pay. Now, my lord, the execution case is proceeding. I am the decree holder. There is an eviction decree against them. But
if there is no stay in the miscellaneous appeal, the execution case will proceed. Revival of the appeal will not revive the order of stay, which was never there. In the misappeal, they were not enjoying any stay.
In misappeal, there was an identity order of stay, but the stay if the misappeal is
was not
revived, the
enjoying
stay
that.
application will be pending. They can prefer any type of application, any type of prayer over there because they are the degree holder.
In the misappeal, on the day when the misappeal was dismissed, there was no stay in your favor.
no,
There was stay.
Stay was there.
There was stay. I'm citing the order, my lord.
Show me that.
There was interim stay granted. Page 49. No, my lord, that is not page 49. Interim stay was there. Yes, my lord, page 42.
that should be, my lord, on
Stay was granted in the
conditional on occupational charge, my lord.
Initial stay was granted in the first miscellaneous appeal.
Yes.
The respondent appeared and took this plea that the miscellaneous appeal is not maintainable since it is not come under the purview of order 43. And then the miscellaneous appeal dismissed as not maintainable. And the learned court held that the regular appeal to be filed. Immediately, my client approached.
When is your date in the execution case?
The next date is on, my lord, 17th of April.
April, I know.
17th of April, my lord. I have the order, my lord. I will place, my lord. This is 17th of April, my lord. This is the last order.
Seventeenth April also, nothing will happen. LCR awaited. I will ask him to dispose of the misappeal within a specific time frame.
My
That I can do.
my lord.
Restore it, dispose the misappeal, and your title appeal. will-
Kindly record my undertaking that I will withdraw the title appeal.
That is the best course of action.
My lord, let them withdraw the appeal within a particular period. Thereafter, my lord, the misappeal will proceed, my lord, within a particular.
This revisional application is directed against an order dated May 13, 2025, passed by the learned additional district judge, second court, Shrirampur, in misappeal number 11 of 2025, whereby the said misappeal has been dismissed upon holding that the same is not maintainable. Same was not maintainable. Full stop. Paragraph. The petitioner is a judgment debtor. Full stop. A suit for eviction.
Suit for eviction.
A suit for eviction of the petitioner had been instituted by the opposite party herein. Suit, what was the suit number?
Suit number was page 15, my lord. Title suit number
108
of 2006.
Being title suit number 108 of 2006 had been instituted by the opposite party herein against the petitioner in the court of the learned civil judge within bracket junior division, first court at Shrirampur. Full stop. The said suit was decreed on.
Degree on, my lord. Page 15 is the degree. I'm saying the date of degree.
Give me the date. I don't find the date.
31st day of August 2009.
Where do I get that?
In page 17. Page 17A is the type copy.
Yes. Decreed on August 31, 2009. Full stop. The said decree was put into execution by the opposite party by filing title execution case number
Title execution number 10 of 2013.
10 of 2013. Full stop. In the said case, in the said title execution case, the petitioner filed an application under Order 21, Rule 97.
The opposite party filed.
You filed.
I filed.
Because of resistance.
Because of
the opposite party filed an application. Petitioner now. Opposite party filed an application under Order 21, Rule 97 of the Code of Civil Procedure, 1908. Full stop. Now, which was registered as miss case number 56 of 2019. Full stop. The said miss case was allowed.
Page 38, my lord.
By an order dated.
Page 38, order dated 18 February 2025.
Order dated February 18, 2025. Full stop. Assailing the said order dated February 18, 2025, the petitioner preferred misappeal number 11 of 2025. The said misappeal was entertained upon condoning. This was also with delay, no?
There was no delay.
Said misappeal was entertained and an ad interim order of stay of execution case was passed on.
On page 42, 5th of March 2025.
On March 5, 2025. Full stop. Subsequently, by the order impugned, the misappeal was dismissed by the learned appellate court, holding the same to be not maintainable on the ground that an order passed on an application under Order 21, Rule 97 was not appealable under Order 43 of the code. Order 21/97 of the code was not appealable under Order 43 of the code. Full stop. The learned appellate court was of the view that the petitioner ought to have filed a regular title appeal. Full stop. Paragraph. The petitioner then filed title appeal number
37 of 2025.
37 of 2025, but the same was barred by limitation by the time it was preferred. Full stop. Accordingly, the petitioner filed an application for condonation of delay under Section 5 of the Limitation Act. Full stop. Such application remains pending.
No, such application was allowed.
Application was
Thereafter,
allowed.
my lord,
Very well. Such application was allowed,
thereafter stay was also granted in the said title appeal.
and that has been what has happened. That
has been vacated due to their fault.
Last time I handed over one order.
This is the
by which the
order
stay
of
has been
stay.
vacated.
ওইটা দিন একটু
এটা কি?
দেখুন ওইদিকে দিতে দিন। That application was allowed, and the execution proceedings were stayed by an order dated January 17, 2026. No, execution was stayed or by which order?
By this order, 17th of January 2026.
When was the stay vacated?
Well, vacating order, my lord, I have
I
submitted.
have handed over the vacating order.
This one, 6th of September. This is 6th September 2025.
No, 12th of March 2026.
I have no.
Yes. The said order, was, however, vacated in view of the petitioner's conduct in not complying with the condition of stay. Full stop. I'll clarify that. Don't worry. Full stop. Paragraph. The petitioner is now up in revision against the order dated May 13, 2025. Full stop. Paragraph. Mr. Bhattacharya, learned advocate appearing for the petitioner, submits that the learned appellate court has committed a jurisdictional error in dismissing the petitioner's appeal, dismissing the petitioner's misappeal by holding that the same was not maintainable. Full stop. He further submits that the title appeal that has been filed has been filed for a comma, has been so filed, tarpore abar has been so filed on improper legal advice, in as much as the misappeal was very well maintainable.
Page 10, paragraph 28, that is my undertaking.
Full stop. In support of his contention, he relies on a judgment of the Honorable Division Bench of this court in the case of
1980, volume 2 CLJ.
1980, volume 2 CLJ.
Page 161.
Hello. Next. Paragraph. Inviting attention of this court to paragraph 28 of the revisional application, 27 of the revisional application,
28, my lord.
28 of the revisional application. He further submits that the petitioner would withdraw title appeal number 37 of 2025 pending before the learned additional district judge, first court at Srirampur, if it is ultimately found that the misappeal originally preferred by the petitioner was maintainable. Full stop. Paragraph. Mr. Banerjee, learned advocate appearing for the opposite parties, submits that although, comma, fairly submits that although, comma, he does not contest the legal proposition that misappeal was maintainable, yet, comma, he would urge the court to take into consideration the conduct of the appellant, of the petitioner, full stop. He submits that the conduct of the appellant would show that the same is bent upon dragging the execution proceedings so as to deprive the decree holder of the fruits of the decree, full stop. Inviting the attention of this court to the order dated March 12, 2026, within brackets, copy whereof has been handed up to court today, bracket closed, passed by the learned additional district and sessions judge, first court, Shrirampur, Hooghly. In title appeal number 37 of 2025, it is submitted that the order of that after getting the order of stay of execution, comma, the petitioner did not comply with the conditions of stay, and the amount required to be deposited by the petitioner was not deposited, full stop. The stay order has thus been vacated, full stop, paragraph. Having heard the learned advocates appearing for the respective parties and having considered the material on record, comma, this court is of the view that the order impugned cannot be sustained, full stop. The paragraph D. In view of the binding precedent of in form of the judgment of the division bench of this court in the case of Surajmal Jain Supra, the learned appellate court was not right in holding that the misappeal filed by the petitioner was not maintainable, full stop. For such reason, comma, the order impugned is set aside. However, comma, order is impugned is set aside and misappeal number 11 of 2025 is restored to file, full stop. However, comma, this court would hasten, HASTEN, to clarify that in view of the peculiar facts and circumstances of the case, comma, the stay of the execution case granted thereby would not be revived, since
That is, my lord, there is a judgment of Supreme Court.
maybe that is why clarifying that stay is revived only if I don't pass this condition, because that in between proceeding where you are directed to pay conditions.
No, one thing can be done. They can.
No thing, I am clarifying that shall not be revived, since the petitioner has been put on condition. Okhane ki condition, there was condition given there.
One thing,
What was the condition on
while
which
granting
what-
ad interim stay by the misappeal?
Yes.
No, there was no condition, but they have their right to pay before their occupational charge.
Where is the order of stay in the misappeal?
My lord, page 42. Page 42. Your lordship can grant the degree holder liberty to pay for occupational charge, and that should be decided by the appellate court.
Until disposal of the instant appeal, you did not challenge this order.
No, I have challenged the maintainability point. Thereafter, the matter was, my lord, dismissed.
Very well. I'll limit it.
My lord.
I will limit the stay.
That can be limited, but
Subject to payment of occupational charges. my lord.
that can be
That
paid
you
before
make an
the appellate
application,
court,
I'll
not
grant
here.
you liberty. Now, ওটা কেটে দিন, এইভাবে লিখুন। It is noticed that by the order dated March 5, 2025, all further proceedings of miscase number
The impugned order granting police help was stayed.
What is the use of staying the miscase? Miscase was disposed of, isn't it?
No, miscase was disposed of. The order disposing of miscellaneous case was stayed.
No, before that, including all proceedings of miscase such and such, such and such.
That is
until disposal of the appeal.
That is unnecessary, man.
Now, by the order dated March 5, 2025, the order granting police help, order dated February 18, 2025, granting police help had been stayed. Full stop. There is no period mentioned here. Such stay shall continue for a month. Full stop. Mr. Banerjee, learned advocate appearing for the petitioner, submits that the opposite party submits that the petitioner should be put on terms for enjoying the stay order. Full stop. Paragraph. It will be open to the opposite party to make appropriate application before the appellate court. Either during the operation of the order of stay, because 1 month I have said.
But within 1 month I will file.
Yes, yes. Or at any time thereafter. To I said within that.
No, my lord, kindly direct. My lord, after filing such application within a particular time, that will be disposed of.
I'll do that. To make appropriate application for imposing appropriate conditions for continuation of the stay granted by this court. Continuation.
$81.
I'm for the petition.
Yes.
My lord, the instant application arises out of a, my lord, testamentary proceeding. Now, my lord, I don't think that there can be any dispute that, my lord, if there are two wills left by a single person, the later will prevails. Now, my lord, so far as last will, yes, the last will. Now, my lord, today I am appearing on behalf of, my lord, the petitioner, who was named as, my lord, the executor. And
just to cut it short, Mr. Mitro, if I remember on the last occasion, I had indicated it.
Yes.
That if I direct the city civil court to hear out the point of maintainability first before proceeding. That should solve it, because
setting aside the impugned order, because otherwise the impugned order, my lord, proceeds on the basis that my affidavit or my application is the affidavit in support of caveat. Though, my lord, no, my lord, citation was served on me, I am entitled to, under the law, I am entitled to a citation because I am the, my lord, executor under this subsequent will. So I had filed an application for staying of the proceeding on the staying or, my lord, quashing of the proceeding on the basis that, my lord, two probate proceedings cannot continue. This honorable,
right. Either of the two things have to happen. Either the maintainability has to be decided first.
Absolutely.
Or this proceeding has to await the result of the earlier revocation proceeding, which
either
is
of it, either of it. Now the difficulty is, my lord, the order impugned says that you proceed as if, my lord, I have filed an objection to the main.
That is more in the nature of administrative sense, Mr. Mitro, because he has said that there is a contention, so it is contentious.
There is no contention.
Objection to the maintainability is also a contention. In that sense, he is not absolutely wrong. Maybe technically he is.
Yes. Because I normally, my lord, lordship is aware, my lord, that
Absolutely right, Mr. Mitra. There can be no qualms to it that with the caveat, once an affidavit in support of the caveat is filed, it becomes contentious.
Absolutely.
Now, in this case, there is no caveat.
No caveat, no
support of
affidavit in support of caveat.
No affidavit in support of caveat. Therefore, the will could not have become contentious. But now he has treated it as one. I am directing him to dispose of the application first before moving further. Application of the maintainability.
And, my lord, the order has to be set aside. Otherwise, my lord, the order continues to remain. The order continues to remain. Whatever it would be treated as a contentious cause without any written statement.
Yes, Mr. Mukherjee, I have also gone through it. If no affidavit in support of caveat,
my lord, what is the procedure followed in lower courts? Lower court procedure are a bit different from that what is followed in the High Court, in the original side. And in the lower court, first the district delegate, here in this case, the district judge was acting as a district delegate. District delegate, the application for probate or letters of administration or whatever it may be is filed. From there, it goes to a particular court who hears the matter. And if it is contentious, if an application is filed by any of the parties or a non-party who claims right in respect of this, it becomes a contentious cause. In this case, my lord, Mr. Mitro's client claims to have got a letter of administration. Already he has obtained that. And if he has obtained that, he wants to say that because I have got this letter of administration, you cannot file a probate application. This is not correct.
No, wait. There cannot be two grants. In
No. The lordship is absolutely right saying the maintainability is to be taken up. And I'll also agree to a situation that in view of the revocation application already filed before my Lord Justice Majumdar, it's pending. Therefore, the matter is to be disposed of with the revocation case itself. I appreciate that, but the maintainability is to dispose of first. Let the maintainability be disposed
Absolutely.
of. But what I'll
set aside the impugned order.
No.
Oh,
kindly come to the impugned order.
Kindly come to the impugned order of, my lord, 8th of August.
8th of August.
Before that, kindly come to the order, my lord, order number 11 dated 25th July on the same page.
Yes.
OP appears today by filing a fresh Vokalatnama along with a petition supported by an affidavit praying for dismissal of the instant probate case on the ground stated therein, copy not served, fixed such and such for hearing of the petition filed by OP. And now kindly come to the next order, the impugned order.
But 27.5 is not an impugned order. Against that, no revision application has been filed. It is the next order.
25.7. I have not challenged that.
Yes, I'm saying that. Make it clear before the...
May without interruption. With respect to Mr. Mukherjee, I have greatest respect for him, but without interruption, may I? 25th July, I have not challenged. I am showing your lordship what did I file there. I filed a petition. Then kindly come to the impugned order. Petitioner as well as intervener opposite party files Hajira, etc. On perusal of the case record, it appears that written objection has already been filed. Here is my objection.
Yes, he has treated this as a written objection.
He could not have.
That is the procedure which is followed in the
Could
law.
not have.
What to be done?
My maintainability application cannot be treated as a written objection.
I'll do this. I'll say that he'll decide the written objection first and then say whether if the proceeding is maintainable, only then he has right to file written objection, or
Absolutely.
The question of him, not right, the question of him filing written objection will arise.
My lord, Indian Succession Act doesn't have that provision.
What? What?
It has to be in support of the caveat. No caveat has been issued as yet. Caveat citation.
My lord, the caveat procedure is not followed in trial courts. This is to be kept in mind, my lord.
But that is the Succession Act. Original side rules I am not relying on. Succession Act says caveat has to be issued.
We have filed an application claiming that the maintainability is not maintainable as because they have got the letter of administration. There is a revocation application pending for this.
Mukherjee,
And my lord, kindly see.
If the question is pertaining to the merits of the will.
My lord, kindly come to this order.
For that, yes.
Yes.
A written objection on the main matter, agreed. So far as the jurisdiction of the court to proceed with the matter is concerned, why should that not be taken up first?
Why should it be taken up, my lord? If I have got a will in my favor, which is dated 9th of July 2004, and you have otherwise produced a will of 2020, 15 to 20 days prior to the death of the lady who was then 96 years old.
Then Mr.
The revocation
Mukherjee, satisfy me that prior to the filing of the affidavit in support of the caveat, the court can proceed with the probate case, stating it to be a contentious cause.
Yes.
Yes, my lord.
If caveat, if affidavit,
Will your lordship allow me to take out an opposition to this?
No. That's the point of law. You satisfy me on this point that without filing affidavit in support of the caveat, the case can be treated as a contentious cause.
The order itself goes.
Order has misread the written objection as a affidavit in support of caveat.
How can there be a written objection in respect of a application where the defendant has, the objector has not appeared?
Challenging maintainability. That was an application challenging maintainability. Where is that application?
My lord, I have filed a supplementary affidavit. It is annexed, my lord. It is mentioned in my petition as Annexure A. But inadvertently, my lord, it was missed out. Kindly take up my supplementary affidavit.
Supplementary affidavit?
বললাম যে তুমি ডিস্ট্রিক্ট ডেলিগেটে তুমি এটা ফেরত পাঠিয়ে দাও, জজ সাহেবকে বলে যে এটা ফেরত পাঠিয়ে দাও, আমরা নন কন্টেনশিয়াস প্রোভাইড করে নেবো। তো আপত্তি করছে তো নন কন্টেনশিয়াস প্রোভাইড করে দেবো আমরা।
Supplementary affidavit doesn't have the application.
Annexure J, my lord, it's 2 pages supplementary affidavit, my lord.
Yes, I've got
Annexure J, I had, my lord, though mentioned in my CO, but it was, my lord, missed out while annexing. Now kindly come to, my lord, it's a short application. Petitioner so-and-so filed the application. Such probate application was filed on such and such. Petitioner, while making such purported probate application, has suppressed material fact. Such suppression now evident, etc. Before making and filing the aforesaid probate application in August 2023, the petitioner was fully aware of the fact that the Honorable High Court at Calcutta, by order dated 27th April 2022, had already granted letter of administration to the applicant in respect of the last will and testament dated 9 July 2020, executed by the testatrix above named in PLA number such and such. Photocopy of the letter of administration issued by this High Court, my lord, is Annexure A. Though the petitioner knew about the said testamentary proceeding and also that the said testamentary proceeding stood concluded by virtue of the orders passed therein, yet the petitioner deliberately chose to make the aforesaid probate application before this learned court without disclosing the said testamentary proceeding. The applicant states that the petitioner suppressed such fact. Then, my lord, kindly come to the prayer portion, page 5, running page 6. In the aforesaid circumstances, it is prayed that your lordship would, your honor would be graciously pleased to dismiss the aforesaid probate application with cost, or in the alternative, stay all further proceedings in the aforesaid probate case and or pass such. This was my application. I did not go into the merits.
Yes, Mr. Mukherjee, it was in the alternative to stay. Then
this application was earlier not served upon us. It has been served in the honorable court. Now, kindly appreciate. No, it was not served. Kindly appreciate one thing. If आगे दिन दीजिए, हाँ. It was served the earlier day. This I've got a copy of this. We've been served in the earlier day. And what has happened in a OS case or in a probate case, Act 39 case, till such time it is become contentious, my friend's client has got no audience. He cannot have an audience in respect of that particular issue. If he wants to get an audience, then my lord, it has to become contentious. If he doesn't become contentious, then your lordship passes an order that it go back to the trial court for hearing on as to the maintainability. Let us see the district delegate.
Maintainability ought to have been heard before registering is a contentious clause. That is what his submission is.
My lord, kindly see the order of 8th of August. Heard the learned lawyer of the objector. The court has heard. It is not a situation he has not been heard.
That is why this application, how could this application be
My lord, if it is not contentious, how can my friend's client be heard?
No. Sorry to say, ma'am. Maintainability.
How can he
merit-
just
one need not go into the merit for maintainability.
Out of the blue, one person will come and say, here, maintainability. Can it be done?
Yes, why not? If he has enough material to show that yes, it is not maintainable.
Enough material. We have also got enough material to show. Your lordship send it for maintainability. We'll see it before the delegate. We'll see it. Let it be sent there.
Yes, set aside the order, send it back.
Administrative order.
No. This is definitely not administrative order.
Your lordship,
this is not definitely not administrative order.
It's an administrative order.
The application ought to have been heard by him before treating it to be a contentious clause.
It is to be registered. It is to be registered and then heard, not before that. It is to be registered as a suit. Or else how can it be heard?
The application was also for stay of the probate case itself.
That is something as well. Two prayers cannot be made under the civil rules and orders.
No. That point is not neither here nor.
Anyway, I am not highlighting that point. I am not highlighting, but fact remains the two.
Anyways, I have a fixed matter. I'll dictate my orders next day. Likhine. Heard. Volume 3 এগুলো দিয়ে দিন দিদি।
sir? 781032.
Volume 3.
Yes, my lord, kindly take page 366, my lord. My lord, your lordship recalls, my lord, I had ended with the Income Tax Act, my lord, on the last occasion, showing that there was no bar. Now, my lord, the other act which was referred to in the submissions was, my lord, FEMA. Now, and the document in support of that, my lord, is a document of 16th of October, 2025. At page 366. My lord, it's the second email, my lord.
Yes.
Now, your lordship will find that this is addressed from HDFC Bank to, my lord, the plaintiff, which says, "Dear sir, please find observations as under. As per the shareholders, there are few addition of new Indian parties who are holding shares in the foreign entity. Please note, all investment and disinvestment are to be routed by a single UIN and under single ADA's authorized dealer, but you made FEMA violation and multiple investments and disinvestment has been done without intimating to authorized dealer banker." Now, my lord, for remittance, my lord, we have to go through, my lord, or, my lord, any investment, we have to go through, my lord, an authorized dealer. Most banks, my lord, have that authorized dealer. Here, HDFC is pointing that out. And they're saying you've gone ahead without intimating us. Then, my lord, it says, please provide reason for violation of FEMA. All these needs to be regularized via LSF, which is late submission fee, with RBI, post that any transaction can be processed. Now, my lord, this related to, if your lordship sees, my lord, who are the shareholders? My lord, here, my lord, Pallavi, my lord, Chakravarti, my lord, has gone out. Amitra has, my lord, gone out of the list.
Most of the names at 367 are
Not legible. My lord, I'm sorry, my lord, there's a probably, my lord, it's more legible in 224, my lord. In CO 224, my lord, it's. No, George. No, that's okay. I didn't, since we were going by. Page 366, 339, sorry, 339.
339 of the other CO.
Yes, CO 224. My lord, the FEMA violation complained of, my lord, here is the transfer from Pallavi to, my lord, Anindo, wife to husband. It says you have gone without informing us, and kindly see the next, I'm sorry, my lord, of CO224, of CO22. What legible chilo now? 339. 339. Is it more legible, my lord? Now, my lord, it says, please provide reason for violation. All these needs to be regularized via LSF with RBI post that any transaction can be processed. So in the list, sir, your lordship will find that Pallavi Mitra is absent. Now kindly come to the next page, right at the bottom for point 3. For point 3, please clarify what is meant by print 5 the LSF needs to be regularized first, post that Pallavi Mitra disinvestment to be reported by RBI. Late submission fee has been initiated to RBI for issuance of provisional acknowledgement of list. Now, 2 points I make here. This relates to the first transfer of shares between Pallavi and Aninda. It has got nothing to do with the buyback which is coming up. And second, all that it is saying is the non-compliance can be regularized by payment of a late submission fee. On the face of it, it shows, my lord, that there is no bar. You should have done the transaction through the authorized dealer. It seems you have done it without following the regulations. So please regularize it. It cannot be void. And in any view of the matter, my lord, there is, my lord, now a decision of the Supreme Court, my lord, which says that, my lord, FEMA violations, my lord, cannot be, my lord, do not render a transaction void. My lord, this is 2020, 11 SCC. My lord, page 1. My lord, paragraph 88. My lord, which should be, my lord, print page 112, my lord. I believe that print page. Print page, my lord, 112. Ah.
112.
Page 88 of the report. And my lord, even if from the report, I have got the online. My lord, para 88, my lord.
Para 88.
My lord, just 3 sentences I want to read. Lordship has that, my lord?
Yes.
Second sentence. First and foremost, FEMA, unlike FERA, refers to the nation's policy of managing foreign exchange instead of policing foreign exchange. The policeman being Reserve Bank of India and FERA. Under FERA, it is important to remember that section 47 of FERA no longer exists in FEMA, so that transactions that violate FEMA cannot be held to be void. Lordship has that? So, my lord, 24 and 27, my lord, of the Contract Act, my lord, will not be correct. My lord, it's not, my lord, cannot be, my lord, void for FEMA. Now, my lord, I had yesterday, my lord, made a submission to your lordship. In fact, I'll come to that last. Now, my lord, I showed your lordship, my lord, the jurisdiction clause. Just Modi.
Foreign courts having jurisdiction.
Yes, my lord, I'm not troubling your lordship with the clause, my lord. But I just want to show, my lord, the view of the Supreme Court on this. To that, my lord, they say, my lord, that in private contracts, my lord, this is, my lord, an absolutely valid clause saying jurisdiction and, my lord, governing law. My lord, that's 2003. That's Modi Entertainment case, my lord. 2003 4 SCC 341. My lord, kindly see, my lord, the issue which was involved here. Para 4, 24. My lord, 24-4, my lord, if your lordship kindly takes. 24-4. Page
360.
Yes, my lord. No, I don't want to show that. My lord, kindly see, my lord, 24-4.
Yes.
My lord, a court of natural jurisdiction will not normally grant anti-suit injunction against a defendant before it where parties have agreed to submit to the exclusive jurisdiction of a court, including a foreign court, a forum of their choice in regard to the commencement or continuance of proceedings in the court of choice, save in an exceptional case for good and sufficient reasons with a view to prevent injustice in circumstances as which permit a contracting party to be relieved of the burden of the contract. Because it's a contractual provision. If you want relief against it, my lord, a case has to be made out. And this selection of foreign forum, my lord, is, my lord, perfectly valid. And this, my lord, is in paragraph 11, elaborately dealt with also. The lordship will find. My lord, kindly, my lord, it's what is referred to, my lord, as, my lord, a neutral venue or a chosen venue. My lord, that's para 11. Yes. My lord, in regard to jurisdiction of courts under the Code of Civil Procedure over a subject matter, one or more courts may have jurisdiction to deal with it, having regard to the location of immovable property, place of residence, or work of a defendant, or place where cause of action has arisen. Where only one court has jurisdiction is said to have exclusive jurisdiction. Where more courts than one have jurisdiction over it, they are called courts of available or natural jurisdiction. Now, kindly note this. The growing commercial activities gave rise to the practice of parties to a contract agreeing beforehand to approach for resolution of their disputes thereunder to either any of the available courts of natural jurisdiction and thereby create an exclusive or non-exclusive jurisdiction in one of the available forums, or to have the dispute resolved by a foreign court of their choice as a neutral forum according to the law applicable to that court.
Thereafter, it's
yes,
important.
it is a well-settled principle that by agreement, the parties cannot confer jurisdiction where none exists on a court to which CPC applies, but this principle does not apply. So, my lord, it's absolutely, my lord, a valid, my lord, contract in that sense, my lord, and, my lord, more importantly, my lord, the shares are of a foreign company. The citers, my lord, of shares, your lordship will kindly take Vodafone's case. My lord, the courts have recognized, my lord, the citers of the shares is where, my lord, the registered office, my lord, of, my lord, the company is. My lord, page 124, my lord. Kindly come to page 124. No. Page 124. Para 347. Page 736. Page 736.
Yes.
My lord, para 347. Kindly see, my lord. Citers of the CGP share stands where is the next question. Law on citers of shares already been discussed by us in the earlier part of the judgment. Citers of shares situates at the place where the company is incorporated and or the place where the share can be dealt with by way of transfer. The CGP share is registered in Cayman Islands, and materials placed before us would indicate that Cayman Islands law, unlike other laws, does not recognize the multiplicity of registers. Section 194 provides company, etc. declaration. So, my lord, citer says, my lord, where, my lord, the registered office, my lord, of, my lord, the shares are, of the company is. Here, my lord, it's in the UK. আর ওই 50 যেটা বার করতে বলেছিলাম সেটা কোথায় 62 So, my lord, first, my lord, I say, if I may just summarize, my lord, that, my lord, appeal itself, my lord, was not maintainable. It's an appeal, my lord, from a postponement, my lord, of, my lord, an issue. Second, my lord, in any view of the matter, my lord, there was, my lord, a jurisdiction clause which has been completely ignored. Third, my lord.
So, according to the jurisdiction clause, the suit itself might not have been entertained by the court.
Correct. Then, my lord, the third, my lord, issue, my lord, is my lord, in any view of the matter, my lord, the reliefs which have been sought, my lord, in the appellate, my lord, forum, my lord, is contrary, my lord, to, my lord, the relief which was, my lord, consideration of which was postponed, that ought not to have been entertained. Fourth, my lord, I had submitted, my lord, that actually there are no reasons. I'll just elaborate on that in, my lord, 2 sentences. And fifth, my lord, is the 2 acts, my lord, which have been referred to. My lord, Income Tax Act and FEMA do not render the transaction, my lord, void. So, my lord, there really, my lord, could not have been, my lord, any, my lord, injunction, my lord, on proceeding, my lord, with, my lord, injunction on preventing, my lord, the sale. Now, my lord, kindly have a look at the impugned order once, my lord. I want to just make good this point about, my lord, no reasons have been given. My lord, kindly take the impugned order once. My lord, it's also at page 51 of volume 1 of the first revision. Revisional application, my lord, kindly.
Yes.
My lord, kindly, my lord, take, my lord, page 53.
Yes.
My lord, middle of the page. Heard the learned advocate for the plaintiff appellant. Your lordship has that. Peruse the voluminous documents filed by the plaintiff/appellant and other materials on record. Considering the urgency of the matter and finding prima facie, what's it? Prima facie, what is it? Case. Finding prima facie, no, it's not case. In favor of the plaintiff, in view of section 24 and 27 of the Indian Contract Act and section 50 CA and 56 2X of the Income Tax Act, and also finding the balance of convenience and inconvenience in favor of the plaintiff, I am of the opinion that at this stage it is necessary to prevent irreparable loss and injury caused to the plaintiff. Urgency is also evident from materials on record, and if an ad interim injunction as per prayer A of the instant application is not, then there is every likelihood of multiplicity of proceeding. Thus, I am inclined to allow the ad interim order at this stage in respect of prayer A. The prayer of so-and-so and anti-suit is refused at this stage, as the said relief can be granted sparingly in rare and exceptional circumstances and without affording an opportunity of hearing such an order cannot justify. Now, my lord, my first submission is, my lord, in view of section 24, 27, 50 CA so-and-so, and finding is not good enough. There has to be, my lord, a what and why. And that is what our High Court, my lord, has held. And, my lord, which has...
Justice Banerjee judgment.
Yes. And, my lord, in the Birla matter, my lord, the division bench of presided over by Justice Dipankar Datta, my lord, confirmed that, approved that. And, my lord, not just that, even in the Supreme Court, now, my lord, bench presided over by Justice Datta, my lord, has, my lord, reaffirmed it again. And that is also an Asma Latif, which I have cited. So, my lord, kindly take, my lord, 143 company cases, 551. My lord, kindly have a look, my lord, at paragraph 10, 11 and 12, my lord. 10, 11 to, my lord, 13. 10 to 14, actually. In passing the order under appeal, the Company Law Board has completely abdicated its jurisdiction and obligation as to the decision-making process. The order passed may as well be a rubber stamp prepared to be used in every case where the Company Law Board is of the opinion that amendments prayed for should be allowed. There is no reference to any fact or the context in which the amendments were sought and allowed. There is no mention of what grounds were urged in opposition and why such grounds were unmeritorious. The tribunal need not have expended pages over the matter, but it was necessary to indicate why the order came to be passed. Judicial orders of such nature need to be met the twin tests of why and what. It is the why that sustains the what. Reasons are the safeguard against the ipsit exit of the decision-making process. They discuss how the judicial mind has been applied to the matter in issue and convey the nexus between the matters that have been considered and the conclusion based thereon. The justification and reasonableness of a conclusion depend on the reasons given in support thereof. Order impugned has no element of why for the what therein to stand on. It is also of some significance that the impugned order has been made at the threshold of the proceeding, where a petitioner has to pass the just and equitable test before he can have a look in. The Company Law Board has inherited a jurisdiction that has a rich legacy. It has the authority in such jurisdiction to hold that a perfectly legal act may in the context be inequitable, or that an apparently illegal act is justified in the context of an essay. This is talking about 397, 398. The order impugned does not show inadequacy of reasons. It has no reasons at all. And in giving no reasons and making the order a question of law, and the impugned order is set aside. Now, Millard, kindly take, Millard, the Supreme Court judgment. Millard, in 2025 SCC Online, SC 512. Kindly take paragraph 5, Millard. Millard, the second sentence. Fourth line of para 5, Millard. Whether or not there was an application of mind can only be disclosed by reason, however briefly alluded to. If any authority is required, one may profitably refer to the decision of this court in Rani Lakshmi Bai. What follows from the above is that the what, that is the conclusion, must have the why, that is the reasons, at least in brief, to stand on, which is conspicuous by its absence in the impugned order of affirmation. On this short ground, we set aside the revisional order. And in Asma Latif, Millard, which I had cited, Millard, day before,
Yes.
Millard, kindly take, Millard, para 58 of that. Kalke diyechi, kalke diyechi. Oh. Now, to me, Millard, paragraph 58, Millard. It is one of the cardinal principles of the justice delivery system that any verdict of a competent judicial forum in the form of a judgment/order that determines the rights and liabilities of the parties to the proceedings must inform the parties what is the outcome and why one party has succeeded and not the other, the why constituting the reasons and what the conclusion. Apart from anything else, insistence of the requirement for reasons to support the conclusion guarantees application of mind by the adjudicator to the materials before it, as well as provides an avenue to the unsuccessful party to test the reason before a high court. Now, my lord, this being the position, my lord, in my respectful submission, my lord, this order, my lord, cannot, my lord, stand at all. Subsequent events that are yes. Now, my lord, is it on record in one of the my lord, in the third revision, I've also put on record, my lord, my clients, my lord, had moved, my lord, the UK court, my lord, to enforce, my lord, the jurisdiction clause. And, my lord, an anti-suit injunction was, my lord, first passed as an ex parte order. Notice was given, my lord, to, my lord, the plaintiff here to appear. Plaintiff did not appear, sent, my lord, some, my lord, representation. My lord, thereafter, my lord, there has been a final order on the application, my lord, for, my lord, restraining them from proceeding with their suit. But, my lord, they say that order is a nullity and they are proceeding with the suit. My lord, that is, my lord, one fact I wish to bring your lordship's notice to. It's on record also, my lord, in the third revision. Before the single judge? No, last rejection the kothay hoyeche. And, my lord, your lordship recalls, my lord, that, my lord, the appellate court had said, my lord, that it would reserve, my lord, will hear, my lord, on anti-suit, my lord, later. My lord, that has been heard and my lord, it's been rejected. My lord, that order, my lord, I can put on record. My lord, that was, my lord, it just happened a few days ago, my lord. 27 March 2026. My lord, no doubt, my lord, they'll come up against it, my lord, but this is, my lord, the order which has been passed, my lord. No, just give the order. No. My lord, just for, my lord, completeness sake, my lord, it's really so that all facts, my lord, are, my lord, before your lordship. No. Radiation multiply. You talk about it 30 times in conference and you can't even get that paper out. My lord, very, my lord, naughty bunch, my lord. Pocket ek mujhe rekhe do. My lord, I'll give that, my lord, in due course. Those are খুঁজেই পাচ্ছে না দিয়ে দেবো পাবো যখন তো খুঁজে এখনো পাচ্ছে না সো এফিশিয়েন্ট পরে চ্যালেঞ্জটা করো সার্ভিস হয়ে গেছে তোমরা কালেক্ট করে নিয়েছো রিজেকশন হবে কিছু আচ্ছা হ্যাঁ ফাইল করো আগে I've concluded.
Well, I was trying to impress upon my learned friend. He said, my lord, he's more like a demigod to us. He said, my lord, that the application for anti-suit was rejected on 27th March 2026, and we will file a revision application, my lord. And the revision application number is, my lord, 1618 of 2026. Whenever, my lord, next week the matter is taken up, kindly, my lord, tag this matter also. This is my only prayer. Yes, yes, so that we can have a all comprehensive, my lord, because kindly see in this case, there were 3 pleadings we made. One is, my lord, so far as the restraint of my employment is concerned. That was granted on 14th of 11/2025, extended on 9th of December 2025, then on, my lord, 2nd of March. Now, they say, my lord, they have got no problems with that. That's the submission at least. Now, the second one was the shares. That is pending before this honorable.
This is the number.
Oh, sorry, 1218 of 2026. Kindly, my lord, pass an order so that.
My lord, I hope they'll serve us.
আরে সার্ভিস হই বস এটা করব না আরে আমারটা তোমায় দিয়ে দেবো তোমার সরি I get
when will we have it next?
My lord, any day. My lord,
they will be there.
no, my lord. I had indicated that had been difficulty, my lord, next week, but kindly keep it next week so that the matter can.
Yes, yes.
So, reply is concerned, you will be required.
I'll, my lord, come, my lord, for that. Because 3 of them will speak. 3 of them will address.
Except, no, certainly not. So, excepting, my lord, witness action, my lord, everything completed. Suit can be decided here.
Yes.
As per
That
Mr.
will-
Mukherjee's submission.
That is better.
What is the order? What is the order? Both the courts below, the trial court and the lower appellate court, confirm there is a prima facie case. I will go into that part. Both the courts, my lord, confirm prima facie case. So this is a concurrent finding so far as the prima facie case is concerned, and pass the interim order as not sought to be challenged. My lord, I will start with those line of judgment where the Supreme Court as time without number says if the courts below concurrently hold and with some reason passed an interim order, in 226 proceedings is normally not done because it is at interim stage. No objection, it can be relegated to the court below and can be decided. Now, another point raised by Mr. Mukherjee that considering the Jitesh fund, that whether in appeal court you can file. Now, if that is his submission, Mr. Jitesh Pandey is in a larger bench. So we have to wait till that date.
Deferred by Justice Shobha.
That should not be.
Maternal Angel's judgment cannot be deferred, but deferred. No, no. So late. My lord is with me from His Lordship birth here. So late for this mile. I want this at first instance. So that is referred. So Jitesh Pandey he is talking about. Jitesh Pandey says in the appellate court you cannot file. Now that has been altered. Altered view has been expressed. View has been expressed that that it can do it. Bengal Club says Justice Ganguly said. Now that has been referred to large judgment. So if this point is, my lord, the issue to be decided by my lord, then your lordship has to, my lord, restrain yourself from deciding it unless the large judgment decides.
My lord will be a part of the larger.
Maybe. So far as these things, my lord, this is the issue here. Whether this elaborate argument is necessary at this stage where, my lord, no objection has been filed in the court below, court has no occasion to deal with the question of so-called jurisdiction.
Completing Mr. Basu today, or we'll have it on the next
No, another day. This is the main, so far as the, I'm telling you here and now. So far as the factual construct is concerned, Mr. Rai will submit.
Good that Mr. Basu continues till 3:30.
3:30 হয়ে গেছে।
2 minutes is my matter. I don't want to do it.
এমনি হবে না। এমনি হবে।
My lord, may I have your lordship's leave, my lord?
আবার এখন কোথায় যাবে? কোথায় বসা?
I had a
বাড়ি চলে গেছে। আমি করে এলাম তো।
Subject to my lord's convenience.
He will submit, my lord, so far as the factual part, Mr. Mukherjee has argued, he is fully conversant with that. I am not. I am
Both of
very
you are
frank.
appearing for the opposite party.
My lord.
Wednesday, it comments to my lord. No, Mr. I have what?
Wednesday have a lot of matters fixed. It will. Didi. কবে একবার কবে 2 PM কবে রাখা যাবে? সকালে তো রাখা যাবে।
তাই হবে এখন চাপ খুব বেঞ্চে। কি বলছি তোকে দেখ 9 তারিখের পরে রাখতে বলছে এই 9 তারিখের পরে রাখতে বেরিয়ে গেছে আফটার পয়লা বৈশাখ
23rd 2 PM.
23rd.
23rd election is there, not here but in West
My
Bengal.
lord, the only difficulty is that the interim order is expiring on 9th of April, my lord. So if subject to your convenience, my lord, if any time before that. Because again we'll have to come up with a 5th civil division if that is passed.
Supplementary. That
File a
will do.
supplement.
Just file a supplementary.
Not
That will
necessary.
Necessary.
Because before 9th, even if I keep it, I'll not be able to conclude and pass
Absolutely.
orders. It will be of no use.
Inhuman.
My lord, any date prior to, I mean, as earliest as possible, subject to your convenience, my lord.
Because we are on second.
My lord,
Third,
in the
fourth,
second,
fifth,
in the
all
second,
6th, 7th, 8th, where?
in the second week, my lord.
Second week is the week beginning 6th.
Yes.
And which goes to 9th.
On 13th,
14, 15 is a holiday.
13 will be good.
13, 14.
No.
Actually, I will have spoken to Mr. Mukherjee subject to I will not be personally present, but purely for other reasons, my lord, from 11th to 21st. I have already.
22nd, that is why I say. 22nd is
22nd is good. 22nd.
Mine.
22nd 2 PM को लिखे नहीं. Third, Mr. Mukherjee, learned senior advocate, appearing what kind of urgency, who will plead. So that's the sort
No,
of
the-
duty we just
my-
call and rise.
Mr. Rai Chaudhary and myself, this issue was taken with Mr. Dipankar Gupta, who was doing this at that point.
No, we'll be taking up now because of the holidays and broken benches. I couldn't arrange my affairs. I'll be taking up returnable motion someday. I'll be taking up motion someday. Every week I'll compartmentalize it so that every matter is called. It will turn up. Call করে দিন দিদি লিস্ট একবার কল করে কেউ যদি থাকে
Mr. Mukherjee had referred to the anti-suit order passed by the district.
কত নাম্বার?
ওই আমাদেরটাই।
Thank you.
Yeah.
82. 82?
82 minutes for the petitioner. The presence of OP number 1 is also required apart from them.
লাস্ট দিন তো সেটাই তো করলি
সার্ভিস করি মানে হয়েছে কিন্তু
সেটা দিয়ে
they are the opposite party number 2 or opposite party number 1 is also required.
Yes, sir.
Yes, sir.
Maybe because of the resolution they are not there. I'm passing it over then. Unnecessary why should it will be sort of aspersion on them that they are not appearing. I'll have to report that. Chalo, pass.
Oh, sorry. 83.
এগুলো কন্টেস্টেড ম্যাটার, এগুলো কেন কল করছেন? মোশন গুলো কল করে দিন না। কন্টেস্টেড তো রিটার্নেবল মানেই তো কন্টেস্টেড। আপনি মোশন গুলো কল করে দিন যেগুলো বেঁচে রয়েছে, কারণ এখানে তো দুপক্ষ না থাকলে হবে না। কল করুন মোশন গুলো।
না 50 থেকে করছি। 50 আইটেম নাম্বার 50।
আরে মোশন মানে নিউ মোশন, যেটা কন্টেস্টেড নয়।
এইবারে বুঝলাম। আচ্ছা নিউ মোশন হচ্ছে 33
ছাড়া হবে না।
ও আচ্ছা 33 34 35 36 37 38 39 40 41 42 43 44 45
41 দিন, 41 টা দিন। ট্যাবলেট ছাড়া যেগুলো আছে 41
1148
unless both sides are there because of the resolution. If you can bring your other side, I can take. Otherwise, yes, but because of the resolution, they might not appear.
The matter is relating to my lord motor accident claim case, my lord. Motor accident claim case that has been dismissed for default. Thereafter, order 9, rule 9 application has been filed, and that application has been filed after my lord period of beyond the period of statutory period, and my lord, there is a delay of 21 days. That section 5 application has been dismissed. My lord, your lordship knows that. My lord, this is a beneficial legislation.
This revisional application is directed against an order dated May 7, 2025, passed by the learned additional district judge Fast Track Court hyphen III, Alipur in Miss Case number 258 of 2022. Thereby dismissing the said Miss Case. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that the said Miss Case had been filed under Order 9, Rule 9 of the Code of Civil Procedure, and there was a delay of 21 days in filing thereof, yet, such delay was not condoned. Full stop. Paragraph. The petitioner shall serve a copy of the revisional application along with notice on the opposite parties, intimating them that the matter shall be listed next in the monthly list of May 2026. Full stop. Next.
I beg to appeal for the respondent bank.
What is this matter about?
So they have challenged the rejection of the DRAT. Now, what has happened? Decree has been passed in favor of the bank. Now,
they are not there, so no.
Kindly take this matter on. Can be taken up Tuesday, instead of Monday.
Next. Call for motion.
For the petitioner, my lord, but there is a caveat, my lord. Is not there.
68, my lord. I am petitioner, my lord. I have challenged the order dated. My lord, the signature was challenged before the learned court. My lord.
Please take the microphone.
My lord. A petition under section 73 was challenged before your honor because the petitioner has challenged the signature, my lord. The learned court below pass an order to sign there, but the said person signed before 35 years ago, but his father was signed, and the plaintiff filed a petition under section 73 of Evidence Act, and the learned court passed an order that his signature will be taken in the open court. That was challenged before your honor. He cannot challenge because the signature was 35 years old, my lord.
Let the brief come.
Lordship. Annexure E, the petition file, written objection, my lord. Annexure E, page number 50. And the plaintiff filed a petition before the lower court, annexure D, page 47. Page 47.
Where is the order impugned?
Order impugned, my lord. (19/11/2025) last order. 19/11/2025 last order, my lord.
What is wrong in the order?
My lord,
What is wrong in the order?
my lord, in this case, Mr. Anubhav Sinha is engaged. Today he is not present. In this case, the senior advocate, Mr. Anubhav Sinha, is engaged, my lord.
You are there, you have moved it. Why did you move it then?
Lordship kindly urgent today.
Why did you move it then unnecessarily? You wanted adjournment, you should have prayed for. Why did you ask for, why did you start moving then?
Maybe, my lord, to serve the other side.
Advocate appearing for the petitioner. Prays for an adjournment. List this matter in the monthly list of May 2026. Next. This order shall not impede the proceedings in the learned trial court.
Lordship will not take up the returnable matters.
If both sides are not there, I will not.
Here, my lord, one matter I have mentioned before your lordship, my lord, that
if both sides are not there, I will not take.
No, other side is also here, my lord.
The side is there. If he is ready and willing, we can.
Because what happened, my lord, on 16 March, my lord, there was.
That I understand, Mr. Kali. Bring your other side if he is there. Otherwise, I will not take it. Cholo. Call korun didi. Daniye jaben.
Let it be taken up, my lord.
89.
85, my lord.
No, we'll go serially. Cholo. আপনি দাঁড়িয়ে যাচ্ছেন কেন?
31, my lord, I am appealing for the petitioner, but there is caveat. There is urgency. That is why I mentioned the commission investigation has been allowed in respect of the beyond the suit property, and that is permissible. I am not saying, but Other caveat I cannot.
It is there, otherwise I would have taken it.
Then my lord, that will apply here. If some precedence, my lord, so that 6 is the day.
I'll fix motions on some day. I'll take it up. Next.
73, I am for the petition. But this is the my lord, petition is 82 years old, my lord. He has come, my lord, for expeditious disposal, my lord. And
শেষ করে দিই, যেগুলো পেন্ডিং আছে ছেড়ে দিই।
the suit is 1960, my lord. Title execution case has been filed, my lord, in 92, my lord. After that, amendment was filed in 24. From since then, my lord, that is pending, my lord. During period, my lord, 160 application has been in this case 160 has been filed.
Case has been filed by the
my lord,
opposite party.
by the opposite party. And on that respect, my lord, this case hearing has not been concluded, and court has been directed, my lord. Hence, the stay is allowed till the adjudication of this case, till effective disposal of the instance case. So you have to kindly direct, my lord, to dispose of
Revisional application 6, expeditious disposal.
Yes, ma'am.
Of
Petition 82 years old, but that should be disposed.
Miss case number 160 of 2024, arising out of title execution case number 93 of 2019.
Yes, ma'am.
Pending before the learned civil judge within bracket junior division, comma first court at Alipur, comma district South 24 Parganas. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that the petitioner had instituted title suit number 526 of 1960 for
61.
For what?
For eviction.
For eviction of the opposite party. Full stop. Such suit was decreed on
from the High Court, my lord, in the year in 2017, from High Court second appeal. Second appeal has been abated, my lord. Entire appeal was abated. 4/1/2017.
Which such suit was decreed, and the decree remained undisturbed up till the stage of second appeal before this court.
Yes, ma'am.
Full stop. Paragraph. An execution case filed thereafter for execution of the decree, being title execution case number
90.
4 minutes for the petition, I have intimated my lord.
He's coming, Lordship. He's coming.
Next. Thank you.
Lordship, I'm led by Mr. Jaisha is on. 75, Lordship.
Your appearance will not do. The petitioner has to be there. You will do the matter. Chalo, call for.
But I'm on the opposite party.
Lordship.
Yes.
Lordship, in item number 75, is it fixed for any day?
Yes. Chalo. 85? Yes. Huh?
Lord,
As per Lordship direction, I have serving.
He is appearing.
Yes, not they are appearing.
the application has already been served. Thereafter, my lord, again he has served pursuant to your lordship direction.
Yes.
But what happened, my lord? The opposite party number 1 and 2 filed an application under Section 8 of the West Bengal Land Reforms Act for preemption. And this was partial preemption because in the deed there are 2 schedules, they pay for 1 schedule. However, my lord, if they got the degree in the trial court, and my lord, thereafter it went to the first appellate. And my lord, the first appellate court hold that since the partial preemption is not maintainable under the law, the order of the Supreme Court, well, the Supreme Court order has been said. So, this suit is not maintainable. But may I give a portion where it has been said? However, thereafter, they came to Honorable Court, and this was heard by His Lordship, the Honorable Judge Honorable. And my lord, His Lordship hold that Your Lordship
will frame additional issue, and here with this issue.
Yes, Your Lordship, I'm giving to Your Lordship.
Yes, it's page 80.
Yes.
Lastly, you had shown, I have marked it.
Yes, we have not writing anything, but the issue has been framed and has been directed by the court to hear out the matter. Your Lordship have seen that His Lordship has been clearly said that page 8. In view of the above, I discuss page 80, my lord.
Yes.
The remanding back the case to the Sasansas with whether the case is barred by limitation, the court below will be decide the issue along with the issue afresh after giving opportunity of both parties to reduce further evidence as well as oral evidence if required in respect of said issues, and after hearing both the parties will adjudicate the same by writing of judgment afresh, preferably within the period of 3 months from the date of Sasansas. Then, my lord, His Lordship held that we have not given
There was no pleading in the written
Yes,
statement.
yes, that's why when an issue has been framed and your lordship, it was a open demand, your lordship. Then, my lord, we filed an application that against that. The learned court
filed an application for amendment.
Amendment for amendment because we have not said anything. You also, if we adduce any evidence that we cannot, because we cannot go beyond the pleading. It is a settled law of the land. Now, your lordship, see the learned court below, my lord, what has been happened. I'll come to my lord.
Yes.
Today, the record is fixed up for hearing in respect of acceptance of additional written statement filed by the opposite party. Learned advocate for both the sides are present and filed hajiras on behalf of their clients. Today, petitioners filed written objection against the acceptance of additional written statement filed by the opposite party. Copy has been served upon the other side. Heard the submission of both sides. Submission of the learned counsel of the opposite. Learned senior counsel for the opposite party has filed the additional written statement in order to incorporate some facts as mentioned in the schedule of the application. He submitted that in written statement PDMT has not been taken in.
I have read it. I have read the order.
Yes, but on that he said that since it has not been written the additional written statement, so I am not allowing it. But as because this honorable court has said that this is the issue and we cannot give any evidence, then we are already out of court because I cannot give it. I cannot give it, adduce the evidence. And your lordship kindly see your lordship order, I am relying upon your lordship.
That is interim order. That is not
yes,
binding
yes,
only
yes.
at
Well,
the final
that
stage.
is the order also you have.
Interim order is interim
Yes, yes.
order.
Your
It is not binding.
lordship order is order. This is your lordship order. Yes, yes.
Interim order. I can
my
always
lord, I
cite
get
that
to-
order at the
Hold
final stage. I may not agree with the order. That is interim prima facie.
Yes.
If
Yes.
that is the stage, then in that case, wherever injunction is granted, suit will have to be decreed. That is not
Yes,
the
yes,
law.
all right. But you also, this is the thing. You also get.
Yes, Mr. Kali. If issue has already been framed, what is the harm in allowing him to file a additional written
I am coming
statement
to
taking that point?
Firstly, my lord, in their written statement before the learned trial court, my lord, they have not taken this
That's
point
right.
at all.
That's there.
That is well said.
What is the purpose? The purpose of the written statement only is to raise an issue.
Yes.
Only if a statement is made in the plaint and that is denied in the written statement, issue is raised. The purpose of written statement is to raise an issue. Whether if you don't raise an issue, you admit it, there will be a decree against you in under Order 12 Rule 6. You have raised an issue. Now the court itself has raised the issue. If the court has raised the issue, this application for filing additional written statement, it remains a mere formality. Issue has already been raised.
Question is, my lord, after my lord, the issue has been framed by this honorable court, and also, my lord, the honorable court, my lord, as it wisdom fit, my lord, things fit, that both the party will adduce their respective evidence, both in the form of.
So therefore, Mr. Kali, evidence will only be adduced to the extent there are pleadings. Now, if the court has directed you to adduce evidence for the purpose of proving or disproving a particular issue,
lordship,
then should it not take within its compass the rights of the parties to amend their pleadings or file additional pleadings also?
My lord, under Order 8, Rule 9, my lord, that is the, my lord, the settled procedure, my lord, for filing additional written statement. My lord, this is not an absolute right. There is no straitjacket formula.
No, not
that,
an
my lord,
absolute right,
at
but
any
in the
stage,
facts of this
question
case.
is, my lord, while the court, my lord, it is the discretion of the court. My lord, it is not that, my lord, it has to be, my lord, a fact, given fact, court can allow. Now, the question is, my lord, in the fact, in the backdrop my learned friend submitted, my lord, this honorable court, while my lord remitting the matter back to the trial court for deciding all the issues, also very much, my lord, aware of the fact that both the parties, my lord, it's a de novo, I would say, my lord, it's a fresh trial. But, my lord, kindly visualize the situation, my lord, when the honorable court has framed the issue. At that point, my learned friend has not said that whether, my lord, he wants to file an additional written statement or not. Well, kindly see the predicament of the learned trial judge.
But the direction, further direction to adduce further evidence, that direction will not carry meaning if he is not allowed to.
That will be also prejudicial to the interest of the lordship. Kindly see, my lord, it is also, my lord, the case that, my lord, the amendment can be allowed
provided it will not cause any prejudice to the opposite party also. The case.
But that is why I am saying, Mr. Kali, that once the issue has already been framed,
issue is already been framed.
The prejudice factor has already been taken
But he has
care
been
of.
allowed to
This
adduce
has happened
evidence.
if it was-
There is not that he has not been allowed to evidence. He has been.
But he will be leading evidence, sans any pleading. What will be the value?
The evidence both in the form of oral and what they will adduce. They will adduce the deed. Lordship kindly appreciate the title deed. Actually, what they are contemplating that by way of a production of the title deed.
Because if he is permitted to lead evidence, issue has been raised, it should be deemed that such a pleading is there.
Well, even if, for the argument's sake, even if it is not there.
But if it is not there, that Mr. Kali, then we are putting the cart before the horse. For the issue to be there, there must be a pleading disputing what is there. Otherwise, there will be no issue. But if plaint is there, if there is no written statement, and then there is an issue, how can that be?
The issue framed by this honorable court.
So that is why it
partial preemption.
It presumes the pleadings.
So therefore, while framing the issue, this honorable court also
That is
permitted.
why, in my prima facie view, this remains a mere formality. If you can show some judgment.
The judgment, my lord, I have also, such some of the judgment I find, my lord, that this right, for filing additional written statement is not an absolute right.
That is no doubt. It's not an absolute
right.
But in the facts of this case, where the court has said that this is the issue, this issue along with all other issues, you lead evidence. So it is sort of an open remand.
See the predicament of the learned trial court, because once the issue has been framed by the this honorable court, and also, my lord, this has also been stated in the order itself, that both the parties will adduce their respective evidence both in the form of documentary as well as oral. So therefore, my lord, the honorable court was very much, my lord, oblivious, I would say, my lord, of the fact that since, my lord, this issue has germinated, so therefore further pleading in the form of by filing additional written statement would not be required, because after all, at the stage of forming of issue, again going back to the, my lord, putting the, my lord, the cart before the horse, in my respectful submission. Because, my lord, once, my lord, this particular issue has been framed by this honorable court, my lord, now the learned court below, my lord, cannot now assail the order of the honorable court and say, very well, I am allowing to adduce, I am allowing you to file additional written statement, and again, my lord, because issue has already been framed. In support of the issue, normally what happens, after filing of the written statement, issue has normally been framed. But here issue has been framed, and my lord, learned friend is not going to be prejudiced by any means, because he has been allowed to adduce evidence both in support of his whatever, my lord, the contention is this. Because this court has framed the issue, and also a time limit has been framed within 2 months. This issue has to be decided. Now, lordship, after this, my lord, when, my lord, he will be able to, my lord, adduce evidence. But court, at the end of the day, court has to see, my lord, the veracity of the document. Question is, my lord, by way of a document, this point has already, my lord, surfaced. Well, this point court has to decide. Now I cannot take this point that since, my lord, they have not, there is no pleading in the written statement, the evidence can be adduced, because that stage has already gone. If I prefer any SLP against that order, my lord, then now also will lordship kindly see also my position also. I cannot also challenge. So at this stage, I also want this point should be disposed of expeditiously as early as possible. But once, my lord, the court has framed the issue, and also, my lord, the documentary evidence, oral evidence, my lord, that opportunity has been granted both to both the parties. But again, going back to the additional written statement stage, my lord, because after all, my lord, this issue has to be decided. It is an open demand, and also, my lord, adjudicated by this honorable court. The trial court has to decide the issue. And order 8, rule 9, your lordship will find, my lord, may I just read your lordship is aware of this. I don't think, my lord, it is required to be read. But it says that no pleading subsequent to the written statement of a defendant, either by way of defense or setup or counter claim, shall be presented except by the leave of this court. And upon each term, and upon such terms as the court thinks fit, but the court may at any time require a written statement or additional written statement from any of the parties and fix a time of not more than 30 days for
presenting the same. And there are some judgment says, my lord, this is not an absolute right. Discretion has to be exercised judiciously. It's not an automatic right that in a facts and circle already issue has been framed, evidence, opportunity of adducing evidence has been given. What more my learned friend want? But
now, if an issue has been framed, you see order 14, rule 1. Let us go to the basics.
Order 6, sorry.
Order 14. Order 14 is issues.
Preliminary.
Yes. Kindly see rule 1, sub rule 5. After reading the plain and written statement, if any,
yes,
ascertain upon what material proposition of fact or law parties are at variance, and thereupon record to frame issues. In terms of the issues, you are to lead evidence. So once this issue has been framed,
yes,
it must be deemed that this pleading of yours is there in the written statement.
May I say, this court says that I have not written anything about this. I am reading this.
Yet this court
then also,
even then the court has framed it. Therefore, the court has consciously framed it as if it is made part of the written statement. That is how it has to be read.
But
so therefore, you are not required to file any additional written statement in such regard, because the court has taken note of that you have not pleaded it. Yet I am framing this issue because this issue has arisen. What is the purpose? You take it the other way around. The purpose is that the parties should know each other's case. What is the purpose of filing pleadings? The purpose of pleadings is that whatever your case is, he knows about it. Whatever his case is, you know about it. Accordingly, issues are framed and both parties lead evidence. This is the sole purpose. Now, he has filed his written plaint. You have filed your written statement. No point as regards partial preemption was taken in the written statement. Yet the court framed an issue as regards partial preemption. Court took note of the fact that your written statement was lacking so far as the point of partial preemption was concerned. Yet the court fixed this issue. Framed this issue. Will it not mean that therefore the court has read into your written statement this pleading? I will clarify that you will be entitled to lead evidence even without this pleading being there.
If I cannot travel beyond my pleading,
that I'll clarify. It will not be said that you cannot travel beyond your pleading because you are traveling beyond the pleadings because of the court's judgment. That is your only worry. That can be taken care of. That will cut short.
Because I have not said anything. That's why this honorable point framed this issue, my lord. That's why I have given that.
I understand that. But that will save time.
Yes, my lord. 2 months has been given to dispose of the entire thing.
Think of it.
Because his right has been sufficiently protected. He has been given opportunity to adduce evidence both in the form of product. Well, that will.
What I have not stated in my
It has already framed it.
I am not.
You read this judgment. 2009 17 SCC 796. Take it down in pen. You will not find it there. Please write it down. 2009 17 SCC.
9
17 SCC.
17.
17 SCC.
796.
796.
Once issues are
2009,
2009 17 796.
17 SCC, page 796. All right, I'll see and I will do next week, my lord.
I think this will solve your problem.
I'll see. Let it be.
My lord, I also want early adjudication. My lord, again, my lord, going back to that point.
I'll see and I'll come back. What I have
also not, it's not unreasonable, because even if additional written statement is filed, it will be filed only to that extent that the suit is barred because
Court has to-
partial preemption could not be allowed. It's any case that is
Not
something.
because he is well protected by well the documentary as well as oral evidence. Well, court has given him ample
Very well.
opportunity.
All right, my lord, I'll show, I'll try to, next Thursday, or not?
Time, matter can be discussed on that day itself.
On that day.
Next Thursday, that is on what? Because এটা বলুন
Heard.
দেখে আসবো কিন্তু
Mr. Khan, learned advocate appearing for the petitioner, and Mr. Kali, learned advocate appearing for the opposite parties. Full stop. List this matter for further consideration. On when is the next date?
Number 85. Then let it be according to list, my lord. আমাদের এটা
Chalo.
The Lordship, is item number 89 has been called.
89 is over. 94 is going on. Chalo.
Lordship, 94 are for the petitioner, Your Lordship.
Answer is there.
My lord, on the last occasion, there was a direction upon me to serve copies upon the respondent.
That side is not there.
No, Your Lordship. May I please file the affidavit of service?
95.
95, my lord.
Both sides are there. 95.
No, my lord. My lord, today is the date fixed for the filing of report by the receiver, my lord. And my lord, accordingly, the receiver has, on the basis of the report.
Your other side is not there. You have a resolution. How will I take up the matter?
My lord, the date has been fixed by the landed court on 22nd of May, my lord. Kindly fix the date, my lord.
Before that, it will be taken up. It is being taken
My lord,
up.
kindly fix the date, my lord, prior
No
to that.
fixing. It's there in the list. Cholun, call korun. Apni theme jaben na. All যখন হবে তখন হবে। চলুন next.
One hundred nine. 109. Not
For the petitioner in this matter, my lord. But this matter should be written in the position.
All of them will retain. Thank you.